Good morning, everybody, and welcome to each and every one of you. Thank you for signing up and registering for this ULS training. My name is Agatha Gloria Itiang. I'm an associate at Chagawa and Utatina Advocates, which is also known as Dentons. I'm your moderator for this webinar, and it's my absolute pleasure to moderate today's discussion. We have a wonderful and an exciting lineup of panelists today. For the benefit of those that may not be aware, today's webinar is on commercial contracts. The title of the topic gives away what to expect, but by the end of this webinar, we hope that you'll be able to know how to allocate risk in commercial contracts, draft dispute resolution clauses in commercial contracts, and structure smart commercial contracts. Now, before we start, a few housekeeping rules are in order. If you have any questions for our panelists, which I believe you will, we request you to use the Q&A function appearing down on your screens, and we look forward to engaging with you. As I mentioned, our panelists are seasoned and proficient practitioners in their respective fields. We'll kickstart this webinar with a discussion from Mr. David Kagwa on drafting dispute resolution clauses in commercial contracts. Mr. Kagwa is a senior partner at Kagwa and Kagwa Advocates with over 18 years experience in construction law, arbitration, commercial litigation. He's also experienced in all fields of commercial litigation and alternative dispute resolution, including international arbitration and mediation. He is the chairman of the Chartered Institute of Arbitrators of Uganda. Mr. Kagwa holds a master's degree in construction law and arbitration from the Robert Gordon University in Aberdeen, Scotland. He's a fellow of the Chartered Institute of Arbitrators in the UK. He's also a member of the London Court of International Arbitration, and he has successfully delivered arbitration awards that have been enforced in the courts of Uganda. So we look forward to Mr. Kagwa's presentation. Welcome.
Thank you, Agatha, for those kind remarks. Good morning, everybody, and welcome to this webinar about drafting contracts. The title of my presentation is The Art of Drafting Arbitration Clauses. Many a time, arbitration clauses are put in contracts right at the end. They are called some are called midnight clauses because usually the parties who are negotiating contracts sign them last at midnight. But I'm here to tell you that the dispute resolution clause should be drafted fast. It doesn't matter whether the numbering is at the end, but it should be drafted fast. The reason why it has to be drafted fast is because parties need to agree from day one how they're going to resolve their disputes. So I'll go straight to the presentation. What is an arbitration agreement? An arbitration agreement is an agreement by the parties to submit to arbitration all certain disputes which may have arisen or which may arise between them in respect of a defined legal relationship, whether contractual or not. An arbitration agreement may be in the form of an arbitration clause in a contract or in the form of a separate agreement. What this means is if you have an agreement, maybe for sale of land, and there is clause 20, which says that all disputes shall be resolved through arbitration. That clause is a separate arbitration agreement from the agreement itself. Now, the arbitration agreement is also defined as an agreement by the parties to go to arbitration in the case of all certain disputes in order to finally resolve the dispute. The dispute may arise between them in contract or otherwise. An arbitration agreement may be a clause in the contract or in the form of a separate agreement. A valid arbitration agreement must clearly choose arbitration over litigation, and most institutions have template clauses. What this means is there cannot be a valid arbitration agreement which says that in case of a dispute, either party may go to court or may go to arbitration. That means that the parties did not choose the method of dispute resolution because both litigation and arbitration are final in their nature. So the parties must specifically choose arbitration as the final mode of dispute resolution, but not litigation. So by saying most institutions have a template clause, I mean most arbitral institutions, such as the one we have in Uganda, ICAMIC, even international ones like LCIA, the Kigali International Center for Arbitration, the Nairobi Center for International Arbitration, they have template clauses which you can use without reinventing the wheel. One example is all disputes arising out of or in connection with the present contract shall be finally settled under the rules of arbitration of the International Chamber of Commerce by one or more arbitrators appointed in accordance with the said rules. This is a very simple and straightforward example of an arbitration clause, which I would advise that you can adopt. It clearly chooses arbitration as the final mode of dispute resolution. There is no wording in that clause which talks about litigation. Another example, which is a bit detailed but also very useful, is a template from the LCIA, the London Court of International Arbitration. It says, any dispute arising out of or in connection with this agreement, including any question regarding its existence, validity, or termination, shall be referred to and finally resolved by arbitration under the London Court of International Arbitration rules, which rules are deemed to be incorporated by reference into this clause. I'll explain the rules in brief. The number of arbitrators shall be 3. The seat or legal place of arbitration shall be London. I'll explain the seat or legal place. The venue shall be London. I'll distinguish between the seat and the venue. These are totally different terms. The language to be used in arbitral proceedings shall be English. The governing law of the contract shall be the substantive law of England. I'll explain all this. Now, this is a standard clause which can be adopted from the LCIA rules. It's very certain, number one, that arbitration is the final mode of dispute resolution. Number two, that the arbitrators shall be 3. It is very clear that the seat or legal place is London. It even spells out the venue. It also spells out the language and the governing law. Continue. Now, a made-up clause, it's basically a clause which incorporates 2 methods of dispute resolution. One is mediation, another one is arbitration. And it's also very important because mediation has been seemed to be much cheaper, less formal than arbitration, and more user-friendly than arbitration. So it's advisable that you have a made-up clause where parties first exhaust mediation before they go to arbitration. And this is an example. Any dispute arising out of, any dispute, difference, or controversy arising out of or in connection with this contract shall first be referred to mediation at the Indian Institute of Arbitration and Mediation, and in accordance with its then current mediation rules as per the Arbitration and Constitution Act. If the mediation is abandoned by the mediator or is otherwise concluded without the dispute or difference being resolved, then such dispute, difference, or controversy shall be referred to and determined by arbitration as per the Arbitration and Constitution Act 1996. So you realize that this clause specifically provides for mediation first and then arbitration as the final method of dispute resolution. Another example is from the Singapore International Arbitration Center. This one is a bit more detailed. It provides any dispute arising out of or in connection with this contract, including any question regarding its existence, validity, or termination, shall be referred to and finally resolved by arbitration administered by the Singapore International Arbitration Center in accordance with the arbitration rules of the Singapore International Arbitration Center for the time being in force, which rules are deemed to be incorporated by reference in this clause. The seat of arbitration shall be Singapore. Seat is the legal place of the arbitration. The tribunal shall consist of dash arbitrators, which means it can be 1 or 3. It can't be 2. The language of the arbitration shall be maybe English or Spanish, depending on how the parties choose. The parties further agree that following the commencement of arbitration, they will attempt in good faith to resolve the dispute through mediation at the Singapore International Mediation Center, in accordance with the SIMC arbitration made-up protocol for the time being in force. Any settlement reached in the course of the mediation shall be referred to the arbitral tribunal appointed by SIAC and may be made a consent award on agreed terms. In other words, a mediator has no jurisdiction to make a decision. The role of a mediator is simply to facilitate the parties to negotiate and come up with their own decision. But in order for that decision to be enforceable, it has to be taken before the arbitrator, according to these rules, for the arbitrator to record it as a consent award. It is only a consent award which is enforceable. In the absence of a consent award, the parties may sign a settlement agreement. It is as good as any other contract. The only challenge is that the settlement agreement has to be enforced through court proceedings. So you may lose the benefits of confidentiality which arbitration confers by doing a settlement agreement, because then you have to file it in an ordinary court. But if you actually sign a consent award, it's as good as a final decision of the court. It's only registered in the court and enforced immediately. Next. Now, these are some of these are some of the requirements under our law, the Arbitration and Conciliation Act of Uganda. The Section 3 provides an arbitration agreement may be in the form of an arbitration clause in a contract or in the form of a separate agreement. An arbitration agreement shall be in writing. It's mandatory. An arbitration agreement is in writing if it is contained in a document signed by the parties, say an agreement, an exchange of letters, telex, telegraph, or other means of telecommunication which provides a record of the agreement. Now, this includes an email, because if you look at that clause, it says an exchange of letters, telex, telegram, or other means of telecommunication. So an email from one party to the other proposing arbitration and agreed by the other party by return of an email is as good as an arbitration agreement in accordance with Section 3 of our Act. The reference in a contract to a document containing an arbitration clause shall constitute an arbitration agreement if the contract is in writing and the reference is such as to make that arbitration clause part of the contract. Let me make it in simple terms. If a contract for sale of land is signed and there's a clause saying that the parties hereby adopt the arbitration clause in the ICAMEC rules, it is deemed that the arbitration agreement is exactly as provided for in the ICAMEC rules because they have been adopted by reference without necessarily reproducing them in the contract. So the 5 layers of law, which are elements of an arbitration agreement. The law governing the contract. Now, before I delve into the 5 layers of law, I need to make it very clear that there is a principle in arbitration called separability, that an arbitration clause is separate from the agreement that it seeks to resolve its disputes from. In instance, if you have a contract, sale of land, it has 20 clauses. Clause 20 says that all disputes shall be resolved through arbitration. Under the principle of separability, clause 20 is separate from the rest of the agreement, much as you're seeing it there. It's a legal principle, and it has a purpose. The purpose why arbitration clauses are separate from the agreement is that even if the agreement is found to be void, the arbitration agreement survives. The reason why it survives is that the arbitrator must have jurisdiction to make a finding that an agreement is void. Now, if that clause was also void, then there will be no jurisdiction that the arbitrator will exercise to make a declaration that the agreement is void. So it is a principle of arbitration that even if the agreement is null and void, even if it's illegal, the arbitration clause survives for purposes of maintaining jurisdiction that the arbitrator will have to make that decision. So the 5 layers of law are as follows. The law governing the contract, this is the main contract. The law governing the arbitration agreement. Now that clause that I've told you is separate. So it sometimes has a separate law that governs it. You can have a law governing the sale of land as the law of Uganda, and you have the law governing the arbitration clause as the law of England and Wales. Now, the seat of the arbitration is the legal jurisdiction of the arbitration. I'll explain it further. The seat is not the venue, so don't be confused by the word seat to think that it's a chair. The procedural rules governing the arbitration and the law governing enforcement. So these 5 layers of law will help us know the procedure we're going to follow in appointment of the arbitrators. We are also in position to know the place of arbitration. The place is basically where we are conducting the proceedings. And then, of course, the language. But those are the 5 layers as stated in this slide. Now, the law of the contract, usually specified in the contract. If not, it may be implied that the laws of the country where the contract was performed will apply. I have told you, because the contract is separate from the arbitration agreement, the law of the contract needs to be specifically stated. If it is not stated, the court may imply that the laws of the country would apply. So in essence, you can have a contract where the laws of Uganda apply, but the law governing the arbitration agreement is the law of England and Wales or Singapore. So it's very normal because they're separate contracts. Jurisdiction. So I've put that chair there, not to mean where you sit, but to draw a distinction. The seat of the arbitration is the legal jurisdiction to which the arbitration is tied. The seat will determine the procedure or rules which govern the arbitration, including arbitrability, timelines for commencement, interim measures, some procedures, powers of the arbitrators, confidentiality, form and validity of the award, finality of the award, including appeal rights and enforcement. To put it in simple terms, seat is that country where either party can go to seek interim reliefs in support of an arbitration, or where either party can go if they have been successful to enforce an arbitral award, or where either party can go if they're unsuccessful to set aside the award. So if you have an arbitration clause which says that the venue of the arbitration shall be in Uganda and the seat shall be London, it means proceedings of the arbitrator will be conducted in Uganda at any place. But in case you need an interim order, you need to go to the High Court in the United Kingdom to seek an order. That's the meaning of seat. If either party succeeds in the proceedings in Uganda, they have to file the application for enforcement in the UK because that's where the seat is. So the seat is the legal place, or it is the jurisdiction where the arbitration is anchored. So issues regarding the seat. Do not confuse the seat or legal place of the arbitration with the location. This I've emphasized. I want to give an example. The Court of Arbitration for Sports, the one that determines disputes related to Olympics, sits in whatever country the Olympic Games is situated. By sits, I mean its venue. If the Olympics are in Japan, the venue for the Court of Arbitration for Sports will be in Japan, where the games are. But the seat is always Switzerland. So if you succeed during the proceedings in Japan, but you want your award to be enforced, you must file it in the court in Switzerland. So in essence, the venue for the Court of Arbitration for Sports is mobile. Wherever the Olympics are, that's where the venue is. But the seat is fixed. It is in Switzerland. And the rules are those of Court of Arbitration for Switzerland. So the 5 most preferred and widely used seats are London, Paris, Hong Kong, Singapore, and Geneva, Switzerland. There's a reason for this. These jurisdictions support arbitration. These jurisdictions have developed arbitration over years, and their courts apply these rules more efficiently than other countries. So, and there is limited or almost no political interference in these countries where these seats are. So realize that Most of the people who bring foreign direct investment to Africa, even including Uganda, they prefer seats in London. If you got to know about certain disputes that arose out of the oil and gas sector in Uganda, there were disputes with Heritage Oil and Gas, there were disputes with Tullow Oil. You realize that many of these disputes had a seat in London, but not in Uganda. So I think we have a lot of work to do to make sure that Uganda is the preferred seat of arbitration. So it's based on reputation of the seat and neutrality of the local legal system, the national arbitration law, the track record for enforcing agreements to arbitrate and arbitral awards, availability of quality arbitrators. This is a very key issue. I was introduced as the chairman of the Chartered Institute of Arbitrators. Our mandate is to make sure that we grow arbitrators in Uganda. We are less than 100 chartered arbitrators. So we need to work hard to make sure that there's availability of quality arbitrators in order to make Uganda a favorable seat. Then there's cultural familiarity, efficiency of local court proceedings, location of the parties people, availability of specialized lawyers at the seat, host, location, and quality of hearing facilities, location of the arbitral institution, language, transport connections. So those are some of the issues that determine the preference for a country to be a seat. So the rules of procedure, they can be written by the parties. They can be adopted from one of the institutions. This is the most advisable. Do not reinvent the wheel. If ICAMEC has rules and you realize that they're good enough, simply adopt them. Don't go and reinvent the wheel. Otherwise, you'll make mistakes. They're usually taken from the rules of arbitration. Organizations such as the American Arbitration Association, it publishes them. They're freely downloadable. And the International Bar Association. Other requirements, the place of arbitration, it can be anywhere in the world. I've explained to you, this is not a seat. The place is where the proceedings are taking place. So right now we are in the boardroom of Kampala Associated Advocates. So this is our place of arbitration in case we're having proceedings. But if our agreement had a seat in London, it means if I needed an interim order, I'll have to fly to London to apply for the interim order. So the number of arbitrators depends on the nature of the dispute and the recourses. Now, this means that usually high-value disputes, it's advisable to have at least 3. It's never advisable or even allowed in most arbitral institutions to have an even number for obvious reasons that there cannot be a draw in arbitration proceedings. So it has to be 3 or at least 5. But 5 sometimes is too much. But where a dispute is really low value and it's not that complex, usually a sole arbitrator is sufficient to make that decision. Another factor is sometimes a dispute has mixed fields of expertise that have led to the dispute. Very common, for example, construction disputes. You realize that there may be a dispute regarding interpretation of the contract, which means you may need a lawyer on your panel. And there may be a dispute arising out of quantities, whether a certain amount of money should be paid for the work done, and there's a dispute as to the square meters, so you may need a quantity surveyor on your panel. The dispute also may involve whether money should be paid due to defects in designs, which means you may need an architect to sit on your panel to be able to decide that issue of design. So you realize that you have a panel of 3 experts who are all arbitrators, but who complement each other. One is a lawyer to assist in contract interpretation. Another one is a quantity surveyor to assist in quantities. Another one is an architect to assist in determining issues of design and design liability. So the language, that which is most convenient. So if both parties speak English, don't reinvent the wheel by putting Spanish, because then you need interpreters. And then it will mean that your word, if it is in Spanish, you may need to translate it in order to have it enforced. So English is usually the most preferred, but depending on the parties. Defects in arbitration clauses. The other word for defects is pathological clauses. I don't know why they use the word pathological, but I think pathologists are those who study the science of dead people. So it's a pathological clause because it's dead. It cannot assist you to commence arbitration, but it can be cured in certain circumstances, and I'll explain how. So the seller and the buyer agree that all disputes arising out of or in connection with this agreement that cannot be settled by discussion and mutual agreement shall be referred to and finally resolved by arbitration as per the Indian contract rules. The second contract referred to the Singapore contract rules. One of the contracting parties was from Singapore. Singapore High Court found that a bare arbitration clause, which merely provides for submission of dispute to arbitration, without specifying the place of the arbitration, the number of arbitrators, or the method for establishing the arbitral tribunal, remains a valid and binding arbitration agreement if the parties have evidenced a clear intention to settle the dispute by arbitration. What the court said in KVC Rice Intertrade versus Asian Mutual Resources was that arbitration clauses are not cast in stone. For as long as the parties indicate that they intended arbitration, even if they did not state the number of arbitrators or the seat, it remains valid. For as long as the parties have not said either party can go to court, it means that they chose arbitration as their final method of dispute resolution. So what's the relevant law from the decision in KVC Rice? Under Section 8.2 of the Singapore's International Arbitration Act, the president of SIAC is designated as the statutory appointing authority. We have a similar clause in our Arbitration and Conciliation Act. It is Section 11. It provides that the Center for Arbitration and Dispute Resolution shall be the appointing authority. So in essence, even if the clause is silent on appointment, you just simply file the chamber summon at CADA under Section 11, and you'll have your arbitrator appointed. So Article 11.3 of the model law, this is the Unicitro model law, I'll explain it, provides that where the parties had not agreed on the mechanism for appointment of arbitrators, the default appointing authority shall be the Singapore International Arbitration Center. So we have this under our Section 11. So absence of a method of appointment is not a reason to invalidate an arbitration clause. Next. So where there was no other way to prevent injustice to a would-be claimant, the court is prepared to step in to appoint an arbitrator for the parties. So in certain situations where the arbitrator has not been appointed, the court can come in and actually make the appointment. It happened recently, it must have been last year, Justice Boniface Wamala appointed an arbitrator in a case of ambitious construction at Uganda National Culture Center. So the arbitration clause was silent on who should appoint. The court went ahead and made the appointment. So mere absence of an appointing authority is not a reason to invalidate an arbitration clause. So what is a tiered dispute resolution clause? We go straight to it. A tiered dispute resolution clause involves a series of steps in the overall dispute resolution process, each designed to handle the dispute if it has not been resolved by the previous step. Let me put it simply. A tiered clause is simply that which provides various methods of dispute resolution, one leading to the other. For example, there can be a clause which says that in case of a dispute, the parties shall first negotiate and come up with amicable settlement, failure of which the parties will appoint an arbitrator to help them resolve the dispute, failure of which the dispute shall be resolved through arbitration. So another common one is in construction contracts, the FIDI contracts. They provide that the first decision maker is the project manager. Either party who is dissatisfied with the decision of the project manager would refer it to a dispute adjudication board. And either party who is dissatisfied with the decision of the DAB will finally have it referred to arbitration. So the common approach is provide for a structured time scale for each step because it can be abused. So it's always wise to say if negotiations fail within 30 days, it shall be referred to mediation. If it fails, then it shall be referred to arbitration. Next slide, please. So drafting the tiered clause. The detailed clause will minimize the procedural disagreement and may enhance the possibility of a court treating it as an enforcement. So if litigation is commenced in breach of an obligation to mediate, the court may order a stay of proceedings pending mediation. So in essence, before you go to arbitration or before you file a suit, you need to have exhausted all the methods that have been agreed in the tiered ADR clause. In arbitration, the situation is different because the arbitration tribunal derives its jurisdiction from the parties' agreement to arbitrate. If the tiered clause provides that the parties have first to go to ADR, the effect could be to deprive the tribunal of jurisdiction until the ADR process has been exhausted. So when drafting the ADR clause, it is up to the parties to decide whether they wish to specify a particular ADR procedure or whether they prefer to agree on one as and when a dispute arises. So tiered clauses should provide a mechanism for final, binding, and enforceable resolution of the dispute, typically arbitration, but not both arbitration and litigation. So these are the drafting rules. The golden rule with any dispute resolution clause is clarity in drafting. A clear process, certainty when the process is triggered. Now, this is very clear because there are many people who, it's common among us lawyers, arbitration is commenced and the party says there's no dispute. So there has to be certainty when the process is triggered. This is very usual in the way you draft. So instead of saying that any dispute shall be resolved through arbitration, you can actually expand it further and say any dispute, controversy, difference shall be resolved through arbitration, such that it's wider. It's common if somebody has a debt to say, I don't dispute the debt, so which means there's no dispute. But the fact that it has not been paid remains a difference, it remains a controversy. Therefore, it can be referred to arbitration. So you must incorporate a time frame, beginning and end. One of the methods of doing this is you can say that if mediation is not resolved within 30 days, it shall be deemed concluded. So which means you can go to another step if, for whatever reason, the other party has frustrated the mediation process. Ensure that the decision makers are easily identifiable. Make it clear whether the mediation is to take place before or during arbitration, and state the arbitration award shall be final and binding. So this is a sample tiered clause. I'm going to share this slide. I won't go through all of it, but in essence, it provides for mediation. First of all, it states that if a dispute arises within 30 days, the senior representatives of each party shall write to each other, meet in good faith, and ensure to resolve the dispute. So negotiation is the first part of it. So if dispute is not wholly resolved at the meeting, the parties will attempt to settle it by mediation in accordance with the ICAMEC mediation rules. And then you realize that the last part, the mediation will start not later than 30 days after the date of the ADR notice. No party may commence arbitration in relation to any dispute arising out of this agreement until it has attempted to settle the dispute by mediation, and either the mediation has terminated or the other party has failed to participate in the mediation. If the dispute is not settled by mediation within 60 days of commencement, the dispute shall be referred to and resolved by arbitration. And you realize that this clause is very clear on the timeline. It's also very clear that conclusion of one method of dispute resolution is a condition precedent to going to another method. So this sample clause can easily be downloaded from the ICAMEC website where the rules are. You can go to the next. So the term pathological clauses coined by Frederick Ainsman is widely used to describe arbitration clauses with apparent defects, liable to disrupt the smooth progress of the arbitration. Such clauses may be a source of conflict for the whole duration of the dispute, from jurisdiction battles to challenges at enforcement. However, not all defects render an arbitration clause devoid of any effect. Some imperfections may be resolved through the tool of interpretation. So we can go to the next. So sloppy multi-tiered clause, lack of clarity as to when stages begin and end, whether stages are optional or not. So dispute shall be submitted, this is an example, to arbitration according to the rules of conciliation arbitration of the ICC. Disputes which may be resolved by conciliation shall be submitted first to conciliation. Now I realize that there are words like may that are being used. So the parties shall mediate so long as one party believes settlement through mediation is possible, after which the parties shall submit the dispute to binding arbitration. Now you see the words that I have highlighted. So long as one party believes settlement through mediation is possible. So in a way, it's not clear. It is not mandatory in its wording. So it is subject to abuse that a party may actually refuse to be party to an ADR process just because of the wording. Can we go to the next one? So Singapore is one of the leading seats of arbitration, and it's well known for the willingness of its courts to uphold arbitration agreements. And the Singapore court held in Isigma versus Alstom as follows. Where the parties have evidenced, that's a typo, a clear intention to settle any dispute by arbitration, the court should give effect to such intention, even if certain aspects of the agreement may be ambiguous, inconsistent, incomplete, or lacking in certain particulars. So long as the arbitration can be carried out without prejudice to the rights of either party, and so long as giving effect to such intention does not result in arbitration that is not within the contemplation of either party. So certain courts, yes, in Singapore and in London, support arbitration clauses. However badly drafted they may be, for as long as they have a clear intention that the parties chose arbitration and nothing else. So that is all. My presentation. Over to you, Agatha.
Thank you. Thank you, Mr. Kagwa. That was a very rich presentation. And one of the key takeaways is words are very crucial, especially in drafting. And I hope everyone will be left with this fact that contrary to popular belief, drafting clauses is such a daunting task. Thanks to your presentation, I think we are left in a much better position to produce words that are impossible to misunderstand. So thank you very much. Now, I believe we have a few questions from the members. All right, so we have no questions. I presume this was very clear and concise. We thank you, Mr. Kagwa. All right, we'll take a brief break before our next presenter. Welcome back, members. This is the second session. We have with us Mr. Patson Aminaito. He's a senior partner at Signal Advocates, and he will take us through risk management and allocation in commercial contracts. Mr. Remy Trey is a Ugandan and UK trained lawyer. His practice is a blend of both transactional work and commercial dispute resolution. He has worked alongside some of the market leaders in structuring and advising on some of the key infrastructure projects in Uganda, in the energy, oil and gas, health and transport sectors. He also acts for a number of local and international entities in an expansive range of commercial disputes in energy, mining, transport, insurance, banking and finance, to mention but a few. He's also been involved in a number of domestic and international arbitrations under the London Court of International Arbitration. And Mr. Remy Trey, the floor is yours.
Thank you very much. Good morning to you all. It's an honor and privilege to be here to present to you and share my thoughts on key aspects, particularly relating to risk management in commercial contracts. I know the year's membership is full of experience, so I'm not holding out the hold a monopoly of knowledge, but just to share a few aspects that I've picked, from my experience, from my training, as well as education. I'm sure that along the way you can as well chip in, to share your thoughts on some of those topical issues, particularly on risk management. Yes, so my presentation will cut across 3 segments, particularly understanding, preparing commercial contracts, why you should care as a lawyer. And this cuts across whether you're a dispute resolution person in court that hands in the commercial court, or whether you are in-house counsel who drafts or reviews contracts on a daily. It also cuts across, practicing lawyers who advise clients on a day-to-day on commercial contracts. While the discussion really, centers along commercial contracts, some of the key areas we'll discuss can actually be adopted in other areas, whether contracts that may not be commercial in nature. And pretty much of what is being discussed is also picked from my experience in projects, structuring, particularly in the energy sector, in the transport, as well as health sector. So I believe that discussion is timely to remind us of some of those key aspects, but also as lawyers to appreciate that we're at the center of risk management in the contracts. When we talk of risk management, we tend to leave it to either business people, risk and compliance officers, and we think that we don't have a role to play in risk management. But I hold the view that as lawyers, regardless of the spectrum, we're actually risk managers. The reason why clients come to us is because they want to manage risk. The question is, at what point do you manage it, or do you allocate it, or do you transfer it? That will determine depending on where your bread is buttered. So we'll look at some of the types of risks in commercial contracts and the contractual risk management tools that can be adopted in managing those risks. And then the last segment will be really about what are the takeaways, having discussed the risk management tools. Are there drafting takeaways that we can go with in managing the risk better? So from the onset, probably as in-house counsel or as practicing lawyers, why should we care about a good commercial contract? First of all, we have to appreciate that it forms the basis for nearly all legal and commercial transactions. You know that in our Contracts Act, every contract of above 500,000 is supposed to be documented or written. So a good commercial contract really is not only to pass the legal test, but also to ensure that it documents all the legal and commercial. This tend to establish legal rights in the transaction. From the dispute resolution point of view, you don't want making references to the documents or information outside the four corners of the contract. So you want to ensure that all the rights and obligations are actually recorded and a part of the commercial contract that you've drafted to avoid the parallel evidence rule, especially in the event that there's a dispute. But also in drafting, we have to be aware of the fact that the contract we're drafting might be subject to third-party scrutiny. The third party could be arbitral tribunals. My colleague David took it through arbitration. So there's a possibility that in case of a dispute, such a contract would be subject to scrutiny by arbitral tribunals, and this involves court as well. Will it stand, will the scrutiny to be able to appreciate that the legal rights of the parties are well provided for, the risks have been anticipated and managed? The other third party could be the regulators. Some contracts are subject to regulatory approval, or they may want to know what is in there. You want to be sure that in drafting those commercial agreements, you don't have challenges with regulators, depending on the sector you are involved in. The others could be financials. Some contracts require to be bankable. You may need funding from financials, it could be banks, it could be equity, and the rest of the people who provide financing. So we want to ensure that in terms of the risk management, when the financials are scrutinizing whether the contract is bankable, you've covered all the areas and there are no leakages in terms of risk assessment, management, as well as allocation. But more importantly, these commercial contracts as well reflect the lawyer's competence and understanding, or lack of it, of the legal and the commercial issues. And in most cases, we fall prey to precedents. I think it's a tradition that is big from law schools, from LDC, and there's a tendency to say, I want to pick the previous precedent on the subject to go. And that is a good thing, but also it can be a bad thing, especially if the precedent you picked may not speak to the commercial issues of the parties that are at hand. So the contract you draft is also a reflection of the competence or the understanding. I recall a line in Macbeth poem with the line, "Who drafted this bloody deed?" So you don't want a situation where a commercial contract is subject of scrutiny and everyone is asking who drafted this bloody contract. Sorry for my French, but it's an issue that can reflect on your competence or lack of it. So at least if it is not for the parties, you want to ensure that as a lawyer, when somebody looks at this contract, there's a clear demonstration of depth in knowledge and experience in understanding some of those commercial issues. And a poor drafted contract could also result in negligence claims. I think in the last 5 years, we've seen clients now alive to the fact that lawyers need to take out professional indemnity insurance. And some clients have actually called on those indemnities, especially where they feel, the lawyer did not cover some of the key areas that the commercial contract should have covered. So you need to be aware of professional negligence claims that are coming up against the lawyers who prepared the documents. So if it's not for the client, you want to ensure that you protect your reputation as well as your legacy as a lawyer. Yes, more importantly as well, you note that poorly drafted contracts may not provide a clear roadmap for the resolution of certain stressful events. Some contracts last 5 years. You can imagine if you're drafting a power purchase agreement, it's supposed to last 20 years. So you may not anticipate, but you want to ensure that you've done a risk matrix. You've identified potential risks for 5, 10 years and providing the contract. And in the event that some are unanticipated, how is your clauses on amendment or variation of the contract? So you want to ensure that you anticipate stressful events and you actually manage them. The other key areas, of course, is the fact that some contracts are required for good corporate governance. You might have related party transactions. It's a parent company with an affiliate, a sponsor, and an SPV involved in a tripartite arrangement. So you want to ensure that either from the tax point of view or to ensure that the related party transaction is well recorded, you need to have a good commercial contract. Some of those contracts are also required by an investor, by a sponsor, who are answerable to the shareholders or those who provide money. Yes, so looking at why we should care about commercial contracts, it's also important to appreciate what's the life cycle of a contract before we get into the risks. When we talk of a commercial contract's life cycle, every lawyer needs to be aware of it from the beginning so that it enables your drafting. It gives you insight on exactly why you are providing certain clauses in the contract. And I think one key challenge, which I think is becoming an issue of culture, is us lawyers trying to sit in our offices. Now there's technology, we want to talk back and forth with our clients in drafting, and we don't actually get to understand the commercial deal behind the contract we are drafting. So you've got to appreciate the fact that one, there's always a business need from the client point of view. Why is this contract needed? And from the drafting point of view, you want to ensure that you have fully appreciated the business need of this particular contract. Of course, the next segment, two segments relate to the procurement strategy and tender process. This relates to some of the contracts that relate to procurement entities under the PPDA. It could be a PPP transaction, or it could be within the policies of the organization that procure contract must go through certain processes. So you want to ensure that they have been ticked, because some of the procurement strategies are intended to cover certain risks. It could be conflict of interest. It could be to ensure that there's value for money. It could be an issue of risk management, or maybe to get the benefit. So it's not only for government entities or procuring entities that should care about procurement or tender process, but also private entities that have come up with policies that might be relevant. The other two, of course, is contract award as well as contract management. Sometimes external lawyers are really invited at the point of contract award to review the standard contract that has been provided or to generate the first draft. And other than the in-house lawyers, we may not get involved so much in contract management, and yet it's also very important. So from that process, part of what is really important in the life cycle is to ensure that there's value for money. In the drafting point of view, have you ensured that the stated deliverables under the contract are made by the supplier? And this can enable us to make savings, opportunities during the procurement or contract management processes, but also to enable further benefits through ongoing performance reviews, service improvement, depending on the inbuilt clauses that the council has input to serve the client better. The other key consideration or benefit of contract management is the topic of today's discussion, risk management. Have we identified the issues to the successful delivery of the goods or services defined within the contract? And part of my story is to ensure that if I have a contract, I must first put it aside and evaluate the risks my client is likely to face from end to end. Whether it's procurement, whether it's at the drafting, whether it's at the contract management, or towards the end. What are those risks that are likely to face the client? And what are those risks that can be embedded in the contract? And what risks can be managed outside the contract? Discussion is looking at the risks that can be managed. Ensure that you reduce contractual risks through the robust contract management practices. And then the last bit, of course, to ensure that you have in mind end user outcomes. For instance, managing performance, maintaining quality of services or the goods that are subject to the contract. But in the grand scheme of things, you've improved productivity. This seems to be more from the business presentation, but as lawyers, we actually need to appreciate this when advising our clients, because they're always at the back of their minds in giving you that contract to review or to draft. Yes, so from the graphical point of view, we have 3 segments of contract cycle that are relevant, and each phase tend to have its own risk matrix and risk management tools. The first one, of course, is the contract setup, how to initiate and plan the contract management process. This includes drafting, this includes process. For those who are in procurement entities, it might include the planning and ensuring that there's money prior to setting out this contract. The other, of course, is contract management phase, how to administer and manage the contracts. Some of the key tools are also embedded in the contract, others are administrative, depending on the size and the value of the contract. The other, of course, is the contract closeout, how to close and transition contracts. Part of it we'll discuss through termination. How do you provide an exit strategy out of the contract? Probably 60% of our disputes in court either relate to breach or termination that leads to breach. So how do you exit a contract? Especially early exit, unintended exit, or exit as a result of other extraneous matters that may not have been provided for in the contract. So each phase has its own risk areas and tools on how to manage it. Let's first consider these 2 questions before we divide in our tools. From your practice point of view, whether in-house or external, what kind of risks are we expected to have in mind as lawyers when dealing or drafting commercial contracts? It's a rhetorical question we need to think through. What risks do we actually expect to have in mind as lawyers when drafting or dealing with commercial contracts? And the second question that we should answer at the end of this presentation as well is, what tools can we use to manage or mitigate those risks at the different stages of the contract? It's not enough to draft a contract and you give it to your client to execute. It's also, I think, a pride issue to ensure that that contract was well managed and the outcome was better. To say I was part of that project, I was part of that commercial deal, and I drafted the contract. Parties have not gone to court. They have realized that their commercial needs have been fulfilled. And that takes retrospective discussion on some of these issues. Now, in preparing this presentation, I've tried to do research in the last 2 years. What are some of the hot topics in commercial contracts or hot clauses in commercial contracts lately? And this probably relates to technology penetration, smart contracts, as well as the lockdown and the COVID that happened. It has changed the mindset of businesses and organizations on how they view commercial contracts. And when you look at the list of the hot topics, you will note later that they actually relate to risk tools and risk management tools as well. For instance, in the last 5 years, data protection and freedom of information is becoming a hot topic in commercial contracts. Some of you have been around for 15, 20 years in practice. You will know that probably data protection was not a big deal in most of the commercial contracts, but now it's becoming a hot topic. And the other is intellectual property rights. How do we exploit the value? How do we protect the value? It's becoming a hot topic in commercial contracts. That seems to be only if one was dealing with either patents or trademarks or franchise arguments. That's where probably intellectual property was more pronounced. But right now, even in typical commercial contracts that are not of intellectual property nature, have IP at the heart of the discussion. The other, of course, is confidentiality. We see a lot of non-disclosure arguments required at the inception of commercial contracts. It's becoming a hot topic. And whether or not a party agrees to sign a non-disclosure argument might determine whether the contract will escalate to the next level, including what is the law applicable to such NDAs. Information security is a big hot topic now, whether in the finance sector, in the energy sector, because right now information is the new gold, especially in the field of commerce. With information, people tend to have innovative ideas on how to treat their clients better or how to provide innovative products. So information security now is becoming one of those areas that are provided for lately in the contracts. The other hot topic is financial adjustments, e.g. service credits, pricing changes, and probably it's because of the economic challenges that we go through. Today we have dollar rates going down, oil prices going down or up, the price of steel being affected by inflation, whether in China or in UK. So right now, most of the entities want to ensure that they provide financial adjustments in their contracts, something that was not very typical in most industries, probably save for project contracts or finance documents. Others are variations, acceptance criteria, incentive arrangements like liquidated damages, compensation arrangements where there's loss or breach. And the others could be dispute resolution and exit management. Previously, those were what we call the midnight clauses. Once the lawyer has drafted all the arguments and they're tired, they copy and paste from the previous argument and paste termination and dispute resolution clause without paying, close attention to the nuances around the 2 or 3 parties that they're representing. But right now, they're becoming at the forefront of discussion. The other, of course, is whose terms and conditions will be used. Most industries or clients now have dropped standard terms and conditions, and there's always a fight on whose terms and conditions will be applicable. Something that was not usual in the previous regimes. And here we also have some of the most negotiated terms in 2022. When you look at the most negotiated terms, some of them will discuss them in the risk management. You can imagine limitation of liability clauses. It is something that was picked and pasted. But right now, not only lawyers, but also clients now want to know what's the limit of my liability. In the event that this contract goes bad, am I covered under a limitation? Those of you who review security contracts, especially in this country, I can bet that you will not find any security services agreement without limitation of liability. Although some of those limits are quite, strange. The other is, of course, price charge or price changes. We are moving away from fixed prices now in contracts, and most clients now want to negotiate price changes. What will happen in the event that the dollar goes up or down? What will happen if the price of steel, if I'm handling a project, or price of cement goes down or up? There should be provision in the contract for price adjustment. Indemnities. It used to be a boilerplate clause where each party will indemnify each other, and was a lawyer's take after drafting commercial terms. But right now, parties now want to negotiate indemnities because it is part and parcel of risk management in as far as commercial contracts are concerned. The other is, of course, liquidated damages. They're also now being negotiated. And principally, this has also been brought about by uncertainty in our courts. Right now, if I asked you, in case you succeed in a case for breach of commercial contract, would you know how much court will award? Probably the answer is no, because judges have had different viewpoints on general damages, on aggravated damages resulting from the breach of contract. So what the parties now are negotiating is to ensure that they have pre-estimate of the damages they are likely to suffer in the event of the breach, and they actually provide a formula. It used to be an issue in the construction industry, but we've seen now liquidated damages moving from construction industry to almost all other areas where commercial contracts are closed. The other, of course, is termination. It's no longer a lawyer's clause as well. Right now, people want to know, how do I exit? And the reason why this is becoming more important, especially in the project spaces, is the fact that people invest a lot of money because of a contract. You win a contract and you are supposed to invest, and your nearest time of return or to get profit could be in 3 years. And you must first do capital investment. You can imagine if you've invested heavily and after 6 months, there's a termination for convenience because there's a clause in the contract that says either party might terminate by giving 1 month notice. That is not a breach, but they not serve the commercial needs of the parties. So termination clauses are now being negotiated much more than ever before. And the statistics from the World Commerce Contracting 2022, it was the 5th most negotiated clause in commercial deals. The other, of course, is the scope and goals specifications. This relates to the actual deliverable, what is being delivered under the contract. And I think every lawyer, every business person needs to ensure that the scope or the deal is well documented in the contract. The other, of course, is what we've discussed, payment and payment options. You've noted, for instance, with government contracts, they no longer want payments that are paid to a dollar, they want shillings. Maybe it's because of the exchange rate losses that might be incurred if they're not well hedged in the contract. Others are warranties, cybersecurity and data privacy. It's heavily negotiated together with IP rights, responsibility of the parties, performance guarantees, undertakings as a tool for risk management, confidential information, NDAs, dispute resolution, late payments, as well as force majeure. The last force majeure clause also seemed to be a lawyer's clause. They just pick it from a standard contract and put it there. But you can imagine how businesses struggled during COVID. It was a force majeure event, but probably something that was not well, discussed or drafted. And we tend to have 1 or 2 liners on force majeure, but we never detail, for instance, what amounts to force majeure? What will happen in case of a force majeure event? How should the parties treat the contract? If the contract is not clear on the drafting, we are likely to have a fallback position of common law position on the interpretation of force majeure, which ordinarily would mean probably each party walks away. But you probably committed funds, or the project is midway, or a contract is also midway execution. Now we see in 2022, it was one of the most negotiated terms in commercial deals, probably because of the events that have happened of late. The other key aspect also, before I discussed them, was to have a dashboard, for instance, looking at the most negotiated terms in commercial deals from different perspectives. In blue, you will see all the participants, whether a buyer or seller is concerned about limitation of liability, price change, indemnities, specifications, termination, payment options, warranties, privacy, liquidated damages, IP. And I prepared those in order of priority according to the survey in 2022. On the seller side, you note that price becomes first, second, limitation of liability, indemnities, scope, warrant, termination, payment options, delivery of the product or the services, IP, data privacy, and cyber, and responsibility of the parties, in that order. On the buyer side, limitation of liability is coming out fast. You may want to ask yourself as a lawyer, this doesn't seem to touch the commercial deal. Why is it becoming a very important aspect in negotiation? Then price comes next, indemnities, payment options, termination, specification, liquidated damages, responsibility of the parties, delivery, and data privacy. Now, on the lawyer's side that represent the parties, again, you see a rearrangement on the most important and the most negotiated terms. Lawyers tend now to emphasize a lot on limitation of liability, indemnities, data privacy, termination, warranties, intellectual property, non-disclosure, responsibility of the parties, liquidated damages, and price. And you will note from the legal point of view, those are some of the risk management tools that we're going to discuss. And maybe now the parties are more alive, and by the time they come to the lawyers, they have probably discussed the commercial deal. And where is the commercial deal? Probably it relates to the responsibility of the parties, the delivery of the service or the product, and payment options. They have looked at all the options, but also the scope and the specifications. And by nature of our training, we may not have a lot of input unless we've taken time to understand the industry, the service we operate in. So the legal part tends to concentrate on some of the tools that help parties manage risk in the day-to-day commercial contracts. So I thought I should highlight this before we get into the discussion to appreciate, for instance, why some of the clauses that we thought are just boilerplate clauses we put last in the contract are now coming at the forefront of the negotiations. Why is now limitation of liability an important tool? Why indemnities or termination, yet it is supposed to be drafted by a lawyer and just put in the contract? But it's a commercial risk management tool that now we need to bear in mind. So having that in mind, what do we understand risk to be, and why is it critical in the commercial contracts? When we talk of risk, we really mean, the possibility or probability that an event, for instance, such as changing the interest rates, exchange rate, or economic activity may occur that is not forecast and therefore unexpected. So it's a risk. Sometimes it's foreseeable. Some risks may not be foreseeable. But whether foreseeable and foreseeable, it becomes important that we understand that those risks are probable. And that means either as a lawyer, when you're faced with a commercial deal that you're structuring, that you prepare a risk matrix and see to the extent of the highlighted risks that are probable or not probable, how can I hedge them within the contract? Do I have particular tools that I can use to ensure that my client, if my client is facing a risk of non-payment, I've looked at the assessment of this contracting party, I think they may not pay. So what have you put in the contract to hedge against non-payment? Or if a client tells you that I've entered a contract with this party, well, I've done the due diligence. Based on their financials, I feel they may not perform this contract. So there's a risk of non-performance. So if you have that risk as something that you've highlighted, what risk management tools have you put in the contract? Or are there other tools that may not be in the contract that you can advise the client to implement to ensure that there's performance? We can no longer wait on the court to determine. Sometimes damages awarded by court may no longer be the most that a client might desire. You can imagine a client might want a project. If the project is not completed, there's no amount of damages that can compensate such a person or a missed business deal. So what that means is that our risk management tool, our risk matrix, should be able to cover not only legal, political, and business risks, and then see how much we can advise our clients within the contract on how to deal with those risks. Yeah, so once you've identified the risks, some of those that we will see later, then you need to see, before treating the risk, we must examine, if you have a contract, or you can discuss with the client whether there's any existing effective controls that can be put in place to deal with a particular risk. You also need to ensure that you examine acceptability of the risk to the parties. What is the risk appetite of the contracting parties? Are they able to cover this risk? Or this contract is very risky that the party should not actually engage in? Sometimes when you assess the risk, you can advise the client that I may not be able to hedge this risk and you might lose the money. Maybe you need to walk away out of this deal. But that will depend on their appreciating the risk appetite of the parties. And sometimes as lawyers, we tend to be so risk averse that when we identify risk, instead of allocating it or managing it, you tell a client, please walk away. But the client's risk appetite might be high. All they need is to be advised on the risk management tools or how to transfer it. The other tool we need to examine, of course, is the cost of mitigation. Vis-a-vis any tool that you are going to, to apply. For instance, if there's a cost, if there's a risk of non-performance of a contract, what is the cost of mitigation? If you are an entity that is a procurement entity under, for instance, the PPDA, you will note that then you have to start afresh to procure another party to provide that service or product. What that means is that you might have spent money and you might go back the budgeting cycle. So the cost of mitigation might be so high that you need to ensure that you deal with the risk, beforehand. And what is the confidence in the estimates in terms of either the cost or the risk itself? Have you estimated it to the level that you can be able to provide for it in the contract? And then once you have examined those, then you need to ensure that what options are available. Either you can choose to avoid the risk completely, meaning parties walk away from the deal. What is the reducing likelihood of that risk? For instance, if you are dealing with the inflation risk in a commercial contract, you'd want to see, based on the country profile, is the government managing the inflation so that the risk probably will be reduced in the first 6 months and will stabilize? Do we need to touch the pricing options? Or probably the risk is temporarily so that sooner or later the matters will stabilize? And then reducing the consequences. What are the mitigation measures that you are likely to put in place to avoid such? And then the other could be sharing the risk. This could be full or partial transfer. One of the key risk management tool is actually what we call risk allocation. Instead of taking up the risk, you transfer it to another person, either fully or partial, so that both parties are actually sharing the risk in equal measure or in full, depending on which party is best suited to manage the risk. The other is, of course, accepting the risk or retaining the risk. And you know that I risk non-performance, but I need this deal. I will have my own internal processes on how to deal with this, but I will not put it in the contract. So all those options have to be on the table when you are treating the risk in a commercial transaction. So you have 4 stages of risk management in a commercial transaction that you really need to ensure that you come through. One of it, of course, is risk identification. And as lawyers, we always need to have either a spreadsheet or a chart where we are provided what we call the risk matrix. Have I identified all the risk areas within this commercial deal? And then the next is the analysis of the risk. What's the probability and the consequences of this risk crystallizing? You can put a red, amber, and green. We tend to use color codes in terms of analyzing the risk. There's high probability of this risk. For instance, if you are entering a commercial deal with government, what is the risk of late payment? Looking at how we've been doing in the last 5 years, chances that the government won't pay on time is very high. So if you have other obligations emanating from the commercial contract pegged on payment from government, you're at a risk of defaulting because you know that chances that government won't even pay on time. And then once you've analyzed the risks and the consequences, then you need to look at the mitigation strategies. Some of the mitigation strategies can be inbuilt in the contract. Others could be outside in the contract management space. And then the fourth, of course, is the control and the documentation, ensuring that these risks are properly controlled and documented. Obligations of the parties are fully documented and clarified. For instance, if you know that there's a possibility of non-payment or non-performance, have you obliged the contracting party to procure a performance bond? So that in the event that there's no performance, then you can have a call on the bond. That way, you've mitigated the risk of non-performance, but also you've provided avenue to recoup the money that you might have paid the contracting party in the event that they have not performed fully. So you want to ensure that you look at different assessment criteria. And when you are looking at the risk impact matrix, ensure that you look at the value as well as the risk. When you are dealing, for instance, with high value contracts, how are you managing the risk? Sometimes we've had, for instance, discussions on dispute resolution as one of managing, litigation. You have a contract tenancy agreement, the value is 2 million per month, and you decide we will, in case of a dispute, we'll go to arbitration before a panel of 3 arbitrators. You've not considered the value of the contract. You've subjected this commercial deal to arbitration of 3 arbitrators. Have you considered how much an arbitrator takes? And you've constituted a panel of 3 to the extent that by the time you deal with this arbitration, you've wiped out the entire value of the contract. So you need to assess the value versus the risk and see which one would be better suited. I mean, if you have a tenancy agreement, the value is 10 million. Why are you going into arbitration unless there are confidential issues or unless there are other commercial nuances you don't want disclosed, to the extent that your client is able to spend more money regardless of the value of the contract? So are these routine contracts, and what are the tools that you have employed? And probably in terms of the risk, you need to focus more on high risk contracts or contracts that are strategic to the business, and ensure that in terms of the value, in terms of the risk, they are well managed, assessed, and prepared within either in the contract or outside on how to deal with such risks. So some of these that I will highlight could be financial risks. One of the aspects that can lead to non-payment or non-performance could be an issue of balance sheet, capital adequacy, liquidity, interest, or currency. And sometimes as lawyers, unless we're in the project finance or project space, we do not pay much attention to some of those. Others could be operational risks, internal systems, technology, management. We've seen fraud and change of control, and then business risks that relate to competition, legal, policy, as well as financial infrastructure. You can imagine, for instance, if you do not deal with taxation risk in the contract. Now you have, as we speak this morning, Parliament is discussing the tax bills, and that can either lead to a break in a contract, or the cost of the contract could actually go high. What have you provided in the contract in case there's a change in taxation? It might make a deal not palatable to a particular party, which might lead to a breach. So you want to ensure that such matters are well canvassed in the contract. So some of the risks that we probably know from the legal point of view is, for instance, you could be dealing with a non-existing party. It's not always obvious that you know the party. Within limited, confidentiality, you know that we've had discussions on a mezzanine funding dispute in this country, where the issue was on the existence of the party to a contract. So why it seems to be elementary to any lawyer that you must have contracting parties, it's not always obvious, and you want to ensure that it's well hedged in the contract. And sometimes it could be pre-contracting investigations or due diligence, but also you might want to ensure that you have warranties or representations within the contract so that you are dealing with the right parties. Otherwise, the capacity contract, and the capacity can be different. If you are dealing with a legal person, a natural person, maybe you have less concerns. But capacity contract can be challenging when you're dealing with entities that may not necessarily be a company, or they might have other internal issues from the regulatory point of view that may not have the capacity contract. Enforceability risk, is this contract enforceable? And how have you hedged such risk? Sometimes it could be a regulatory issue, it could be a legal risk as well. If you are dealing with international parties, what is the enforceability of such a contract in their home country, especially obligations that relate to their home country? Invalidity of the transactions, sometimes we have policy considerations in different transactions that could be an issue. Non-performance risk, non-payment, you have reputational risks in some contracts, premature termination risk, litigation and regulatory risk, they're always imminent. IP and technology, privacy and confidentiality breaches. So we'll look at some of the risk management tools that we can employ, bearing in mind some of those risks that we have highlighted. And out of those tools, from the contractual point of view, we need to bear in mind that you underlying contractual risk management tools, we might have risk control tools and risk funding techniques. Maybe for discussion purposes, for instance, you might have insurance as a risk management tool. You are not so sure whether this person will perform, and you take out insurance. So part of it is that it's for the other party to see how they will fund that insurance. Is it out of their reserves? Will it be part of the contract sum? How will you fund that control? Especially if you've been told you must take out insurance as a risk management tool. So I may not clearly define those two as I discussed, but you'll be able to identify which ones are controls, which ones are funding techniques. Yes, so the tools for managing the risks are quite many, and they change depending on the nature of the dispute, of the contract, industry, and the risk appetite. And we'll look at some of those in detail one by one. But what is critical is the fact that when you're trying to allocate risk as a management tool, at the heart of risk allocation, you want to ensure that risk is allocated to the party best able to manage the risk. And the challenge we have is that in most cases, risk is allocated depending on the capacity of the party. For instance, if it is a sale of goods, who has the obligation to deliver? If the obligation is on the seller to deliver the goods to the buyer, so who has the risk in case of an accident or in case of destruction during the transit? Then you don't put that risk to the buyer if the obligation to deliver is on the seller. So the best party to manage the risk is probably the person who is in charge of the delivery. So the fundamentals, one is the fact that risk should be allocated to the party best able to manage it. The second part of it is that also allocate risk when appropriate to accomplish a project goal. Sometimes people allocate risk for the sake because you have, or your client has a better bargaining power, and yet you know that the way you have allocated this risk, you may not be able to achieve what the contract intends to achieve. So you want to ensure that your risk allocation mechanism helps accomplish the commercial deal underlying the risk allocation. Otherwise, you don't want to have clauses in the contract that frustrate accomplishing the parties' goals. So when we talk of the contractual risk transfer, we are looking at shifting of the responsibility from one party to another in a contract. And it's a risk management process as well as a risk management technique. And usually the purpose really is to ensure that you've identified some of the issues, for instance, property. I can give an example of if you are dealing with a construction project and you have construction contracts and you have a contractor on site, who is better placed to manage accidents at a construction site? Is it the employer or the owner of the project or the contractor? So you want to ensure that in transferring the risk, you identify exposures to loss, especially, for instance, property, personnel, income, third-party liabilities, and you appropriately allocate. If I'm the contractor on site and I've signed a construction agreement, you'd want to ensure that part of environmental challenges, part of managing traffic to the site, especially of trucks, is an obligation of the contractor, not the employer, because probably they're on site and managing the site. You also want to ensure that before you transfer the risk, have you examined alternative techniques and which one is the best technique suited? And so that you are able to choose the most appropriate, monitor and change if necessary through variation or amendment
of the contract. So I've given an example, for instance, when you are dealing with risk transfer perspectives. Imagine you are dealing with a construction project. You have owners and you might have architects and construction managers on site, and in most cases, there's a consulting agreement between the owner and the construction managers. Then you are likely to have another contractual arrangement with the general contractors, and you might have other subcontractors. So within that contracting ecosystem, you want to ensure that you've identified risks and see who is in a better position to manage it. For instance, if the owner is concerned about the performance of this project, I want my building up and running in 2 years, and I've contracted a builder, a contractor to manage that project. But I'm also aware that in that contract, I've allowed subcontracting. And maybe 80% of the works have been subcontracted. You'd want to ensure that in the construction contract between the owner and the contractor, first of all, there are performance bonds or guarantees. But also where the contractor has subcontracted, you want to ensure that that obligation is also visited on subcontractors, because you know that failure by the subcontractors to perform is likely to lead to the non-performance as well on part of the contractor. So you want to ensure that in risk transfer and allocation, first of all, you identify who is in better position to manage that, and then you allocate it appropriately. So in all this, you want to ensure that you are aware of the sole remedy provisions in the contract. For instance, you prohibit a party from exercising remedies outside the relevant remedies provision. One of the key contract clauses I love in the contract is excluding common law remedies. If I provided remedies within a commercial contract, in case of breach, you pay liquidated damages. Non-performance, you've picked performance bonds. You also have maybe advance payment guarantees. You've also requested for insurance on some of these aspects. So why would you again allow common law remedies to be read within the contract? Of course, it's a question of interpretation by courts, but you want to ensure that where remedies have been well articulated in the contract, then you prohibit a party from existing other remedies outside what has been provided. And we'll see that when we're discussing termination. The other, of course, is if you have cumulative remedies provision, then you ensure that the enforceability by carving out each sole remedy clause. So, for instance, sometimes you say in case of a breach, you are supposed to remedy the breach within 48 hours. If you fail to remedy within 48 hours, maybe you call on the top executive to discuss, or you have expert determination. In the event of that, then you can go to court. So if you have cumulative remedies provision, then you cannot, for instance, now go outright to termination. It might be a remedy for non-performance, but you want to ensure that you carve out such so that remedies are exercised cumulatively. And then how appropriate are consequential damage waivers in terms of the parties? Consequential damages could relate to unpredictable damages. You've heard of special punitive within the contract in case of breach. I'm one of those who hold the view that actually, unless there are tortious claims, court should never award consequential damages in a pure contractual breach claim. Why? Because they are usually anticipated. And you should be able to provide remedies within the contract where you've been able to look at the risk and appropriately provide for the risk within the contract. If you do not, then you open yourself to all those claims under the contract. And I think there's a couple of Supreme Court decisions from Uganda in the 1990s that have actually indicated that you cannot succeed in claiming general and aggravated damages in purely contractual matters. But I know that the subsequent decisions have parted ways with the earlier decisions. So you also want to ensure that in the contract, you make sure that the monetary cap is a good fit. If you say, if it's a contract for delivery of a car, the car costs 120 million. If there's non-delivery, what should happen? Sometimes you can cap liability to to the subject matter value and pre-estimate any losses. If somebody took out a loan, there might be interest. If they had to break the government bonds pay you, there's a pre-estimate of the monetary damage in the event of non-performance. So if you are making a cap that the liability under this contract is limited to 50 million, is it realistic? Remember, some of these clauses in the contract are subject to contra proferentum rule, and they are always interpreted against the party trying to rely on them. So they have to be very clear, clearly drafted, and the limit clearly defined. Reason being that you risk somebody arguing fundamental breach. If some of you recall Casellas versus Wallace case, if I've contracted you to deliver a Bentley car, you cannot deliver a car with a Kawondo engine and you say you've delivered. And courts have held the view that if there's a fundamental breach of the contract, you cannot rely on some of these risk management tools. The same way when you look at cases relating to provision of security services in Uganda, where some security companies actually limit liability to 1 million when the contract value is more than that, and maybe the breach of the security services agreement was as a result of the participation of the parties or personnel of the contracting parties. And courts have tried to move away from such clauses, especially where personnel of the contracting parties was involved in the in the breach. So you want to ensure that the caps are a good fit and they're not disproportionate to the benefit of its bargain. Your contract, you are taking out 100 million under the security services agreement, but you are limiting liability to 1 million. Is it proportionate? So the other key risk we can look at is pricing and non-payment, and how do you deal with it? From my experience is that some of these clauses in the contract that deal with price, with payment, as lawyers, we tend to leave them to the contracting parties. But it's a legal risk as well. And as lawyers or in-house counsel, we need to pay more attention. If they are provided for pricing and payment, have you considered the risk of non-payment? If you have flagged it as a risk, do you have provisions within the contract to deal with that risk, to hedge that risk? If it is not provided for in the contract, are there other mechanisms outside the contract to hedge against non-payment? Some of it could be creditworthiness. These days, even banks can give a loan based on credit rating or credit history to the extent that they don't need security for loan repayment. Now, creditworthiness could be a risk management tool. If you know that somebody's credit history is good enough, then maybe your client doesn't need to worry about a non-payment. But it's a risk that we all need to be aware of, and at the bare minimum, try to provide within the contract how we hedge against such. So you need to consider, for instance, potential market swings when setting price terms. Consider price adjustments for changes in costs, such as transportation of raw materials. Sometimes you have situations where raw materials go up that can lead to a price adjustment. Or you have transportation issues. You can imagine during lockdown how transport was a big issue, where sometimes fuel could be 1,500, but midway it has gone to 6,000. How will that affect the price? So in the contract, have you considered market swings that will affect pricing terms? Have you also considered competitors' pricing? For instance, by requiring the cost or price to be competitive. Yeah, sometimes you can include most favored customers clause, or you can allow discussions on the price periodically. But what is critical is that you must think through non-payment or price risks and ensure that you provide mechanisms within the contract in the event that some of the market swings actually happen. I know, for instance, in Uganda, one of the things that cause price adjustments in construction is the price of steel that is always affected by the global markets, or oil prices that might affect the transport costs. How have you provided for such in the contract in the event of changes? Otherwise, if you do not, and you say, for me, the risk is on the contractor, you risk that you won't get the project done because the project won't make business sense for the contractor. So the other key concerns that you need to consider is the type of a transaction when determining price. Have you tried to select a pricing structure? Is it fixed? Is it formula-based? Or is it variable? And this will depend on really the commercial transaction you're dealing with, but also the interests of the client. If you're dealing with government, chances are that they will have the price fixed because they have budgetary constraints and they tend to fix the price. That to adjust it, you must go back. And I think government generally does not allow adjustments beyond 25%. So you want to ensure that when you're dealing with government, you are aware of that. But also for other commercial entities, depending on the transaction, you want to ensure that either you have a formula-based, which might be based on time or materials, or it is variable, depending on what works for both parties. The other is, of course, to consider provisions for refund rights in the event that there's price variation. Then determine the payment due dates, because non-payment is a critical component of a risk. You want to ensure that have you considered the specific dates for payments or payments based on the events such as completion of all services. I know now lawyers will tend to use milestones to avoid claims for full legal services at the end. You've handled the case, but midway, you note that the client has withdrawn instructions. If you do not have a service level agreement or provision of services agreement that is clearly determines those milestones and how you'll be paid, then you are likely to have disputes relating to payment. The other, have you provided for right of reimbursement, either for interest charges, collection costs associated with parties having to pursue late payments? Others provide for default interest. Others provide for liquidated damages. But you want to ensure that that is provided for, other than waiting to go to court to claim interest, the interest of which will be from the point of judgment, not default. So you want to ensure that your contract is very clear on that. And then specify requisite invoice requirements, including procedures for disputing invoices. If you have a commercial contract where a party has to issue invoices at different stages, you want to ensure that in case there's a dispute on the invoice, have you provided within the contract on how such a dispute on the invoice will be considered? Either it might be stated that you actually agreed to such an invoice if it was issued and probably 30 days have passed and you've not paid. So you can imagine later, will you be able to raise similar issues on such an invoice? The other, of course, specify whether set-offs are permissible. Set-offs or liens are not necessarily applicable in all circumstances. You note that set-offs and liens are common law terms, and you want to ensure that if you want to take benefit of such, you provide for them within the contract. In the event that you have a related transaction, can you offset from such? If they are permissible, then you must provide for them in the contract. Yes, so the other concern that is important for hedging against non-payment and pricing is to ensure that you specify acceptable payment methods. The mode, the currency, whether it's in dollars, and this is even more important when you're dealing with international transactions. Is it by check? Are you going to do wire transfer? Who is going to incur the cost of the transfer? What will happen if there are forex exchange losses that affect the pricing or non-payment? Who will bear the exchange loss? Then you should be able also to provide the purchaser with the right to prepay or defer payment based on the specific terms. If it's a financing arrangement, is prepayment important to your client? If it is, how does that affect the pricing? For instance, I know like in loan transactions, prepayment is always meted with a penalty. because usually banks have calculated their interest during the term. So if you want to pay early repayment, it might be considered as unpalatable. So they always provide for such. And how do you secure the payments? Do you have security interest? Have you provided for a letter of credit, an advance deposit? Have you provided for a guarantee from a large investor or affiliate or parent company? Do you have performance bonds or surety from the contracting party? So all this is to ensure that if you've identified pricing and non-payment as a risk, then don't leave it to chance. Then you must have these tools to ensure that the adequate provided, so that you provide certainty and predictability that is required in commercial transactions. The other risk that I've flagged is, of course, IP ownership and rights as a risk. Like I indicated earlier, usually these IP rights are usually ignored in typical commercial transactions unless it's your typical intellectual property agreement, either licensing or ownership. So how do you deal with such? The starting point is that, of course, is to appreciate what IP rights are, which are anything that a service provider creates or invents. It could be copyrights, trademarks, patents, or trade secrets. If somebody is a consultant and they are generating documents, they can actually lead to a creation of copyrights or patented works. So if you have contracted somebody to deliver a particular service, have you considered the IP rights that might emanate from that transaction? And have you provided contractual proprietary rights provisions to protect such IP rights? How will they be assigned? If they are created within the transaction, who is going to pay for the services? How about if that chances that a third party sues on the IP? A good example is that you have technology companies providing platforms. You've seen banks procuring core banking systems, or even businesses procuring technology platforms. What if the contracting party has breached third-party IP rights? So if a third party sues, who out of the company or the service provider will pay? Have you provided for indemnification provisions in case of breach of third-party rights in relation to the subject matter of the contract? So there has to be clarity between the parties as to the ownership of pre-existing IP rights and any IP developed under or in connection with the agreement. Who will own any modifications which are made to the pre-existing IP? This kind of disputes are present in the telecom sector and technology companies, and it's something that one has to keep at the back of the mind when drafting these contracts. So always include present assignment language of the intellectual property. For instance, I'm sure for those of you who use Zoom, you've seen some of these clauses that Zoom is employing, much as their standard terms, but you must accept them before you use their Zoom services. You retain copyright or any other rights you already hold in content which you submit or post or display or through the services. If I've used Zoom services, for instance, for my presentation, the rights indicate that I own copyrights to the presentation because I've submitted that during this display. But Zoom indicates that they retain ownership of all proprietary rights in the services and in all trade names, trademarks, service marks, logos, and domain names associated or displayed with the services. You may not frame or utilize framing techniques to enclose any Zoom marks or other proprietary information, including images, text, page layouts, or form of Zoom without express written consent. Now you can imagine if you start putting Zoom logos in your presentation, that would be an infringement. So when we think of commercial contracts, we only think of what we draft, but there are those standard terms that are usually, especially with technology companies, and they tend to have IP clauses well drafted. So you also want to ensure that you have IP clauses that identify relevant law. This is critical where you have cross-border transactions and it's not always obvious which intellectual property law is applicable. Some of the IP developers are from abroad, or people who are using them in Uganda are under a license. So provide identification, provisions. For instance, the licensor has complied with all laws applicable to business, and the licensed intellectual property has complied with all laws applicable to business and all laws applicable to the licensed IP, and both parties also are alive to the applicable laws. That becomes clear on both parties. The other, of course, sometimes is provide warranties where the licensor represents that there are no claims pending or threatened to the knowledge of the licensor. There are no claims pending or threatened, and the licensor also represents that there are no claims pending or to the knowledge of the licensor threatened. That way, if you find that there's an existing litigation that might actually affect the subject matter of the commercial contract, you can actually call on these warranties, which might either entitle you to damages or, depending on how you've crafted remedies clause, specific damages that might be clear to within the contract framework. But also you need to be alive to the fact that when you are having contracting parties that cross the border, there are cross-border enforceability issues with intellectual property rights. There are certain things you may not do under the contract by the very nature of the local law applicable to one of the parties. For instance, when you're dealing with any European, Hong Kong, or Taiwan entity, there are limitations and assignments of moral rights, including the right to list oneself as an author. In Malaysia, there's a requirement that a separate deed of assignment be executed during employment for assignment of patents and industrial designs. So if you're dealing with a Malaysian entity and the law applicable is Malaysian law, you need to be alive to such. In Philippines, it is recommended that an IP agreement be notarized to help the company show that the employee freely signed the agreement. You know that even under our intellectual property laws, there's a requirement that if an employee is going to own intellectual property that is developed in the course of employment, then an independent agreement should be executed. Otherwise, the presumption is that the IP is for the employer. But you see now for Philippines, there's an additional requirement that then that agreement has been notarized. And in almost most of the EU countries, failure to record the patent trademark assignment on acquisition of IP within 6 months of the transfer can render the IP unenforceable and prevent the new owner from recovering damages for infringement. So when you have a commercial deal, it could be an acquisition of a business, a merger, a takeover that relates to an entity that is across the border. You might want to ensure that you take legal advice on some of these cross-border issues that might affect enforcement of IP rights. If a commercial deal really has important IP to consider. The other, of course, is technology and data protection risk. In the contract, you want to be alive to that, but also establish, for instance, when is the review or inspection? Do you have audit rights within the contract? You need to provide when to give full access and restricted audit rights within the contract. Otherwise, somebody who is at risk of losing data might take preventive approach to data protection. But also when you are limiting access, consider information security, proprietary information, confidentiality, third-party data subjects' rights, among others. But also from the contract point of view or contract management, it's also important that you classify data beforehand. What kind of data has full access, which data has restricted access from the contracting parties. You also want to ensure that avoid data protection risks, providing the contract that if somebody wants to access such data, then they must provide advance notice to the other party and the nature of the request that they to be able to access such data, and specify the number of audits that can be done to ensure that data protection is enhanced. We need to bear in mind that currently we have Data Protection and Privacy Act in Uganda 2019 that has to be read within some of these contracts, especially when you're dealing with subject that has clearly highlighted in the law. The other concern that either party needs to be mindful of is default and breaches. Every contract can be breached. There can be default, and we may not go into the causes of default or breaches, but it's a risk that every contracting party needs to bear in mind. And a breach might have far-reaching consequences. And in general, a default clause will let the non-breaching party do one of the following. Either they can choose to terminate the agreement, and sometimes as lawyers, we are quick to prescribe that. But you can imagine in a commercial contract where a party has invested $5 million, $10 million, and they know that this contract is for a fixed time, 5 years, 2 years, the initial 2 years relate to capital investment. And they think that they recoup their money and profit in the 4th year. They can't be thinking of termination in the 1st year or 2nd year. So it may not always be the appropriate remedy in all situations of default. The other could request damages. We've seen contracts that provide for liquidated damages. Or there could be other course of action that a non-breaching party can actually follow, depending on, again, how the contract is crafted. Remember, when we're talking of cause of action, some are contractual, others could be statutory, others are common law. Our Contracts Act 2010 is now quite elaborate in the event that your contract is not elaborate enough. But also, we know that there are default actions that can be taken under common law unless the contract expressly excludes common law course of action. So when you're drafting the default and material breach clauses, it's important that you consider the effect on the performance, because not every breach should result in termination. But in a default or material breach, how does that affect performance? Then you need to list the risks posed by delay or breach. Will the delay affect other obligations? It could be employees, it could be financials, it could be other service providers. If there's non-payment, how will it affect the other contracting party? They might have financing obligations and there's interest. Then you need to list potential remedies, including either specific performance, there could be damages, right to bring in a new party to execute. Some contracts provide for self-help, that in the event that there's a breach, a material breach, I will not need to sue for damages, but I will step in to help in the performance. Others indicate performance bonds. Then the contract also, or the clause, should be able to spell out specific events of default. What is considered as an event of default that would entitle a non-breaching party to the remedies that we've highlighted? Then once you've considered that, then consider adding penalties, liquidated damages, interest as a risk management strategy, so that each party is very clear that if I default, or if there's a material breach in these areas of the contract, these are the likely contractual consequences. That way, you don't have to rely on the Contracts Act or the common law for remedies. The contract is self-sufficient to manage that risk. So the other clause that is very important as well, but given less attention in our jurisdiction, is indemnification and hold harmless clauses. Now, when we talk of indemnification, generally these clauses deal with action of compensating for loss or damage sustained. And most courts have found that obligations to indemnify does not occur until the matter is resolved. Now, when you look at the nature of our contracts, again, we don't think through what risk are we hedging by these indemnification clauses, and what could be the reasons for including indemnification. It's not a matter of course that every contract ought to have indemnification, unless you've identified particular risks that you are hedging against. And some of the reasons advanced for including indemnification clauses in the contract would relate to for instance, privity of contract. Some or all of the indemnifying parties may not actually be a part of the contract, but you believe are critical to the performance of the contract. You can extend that to the contracting party as well as to the non-contracting party. In an acquisition argument, consideration may be paid to several, for instance, equity holders, and may be impractical to recover damages from each. So you can have one contracting party to indemnify you in the event that there's breach and you can't recover from different equity holders. The other could be in relation to breach of representation. A party may have to prove reliance, that either you are relied on your expertise, on your experience, or representation within the contract. That in the event that it turns out that those representations were wrong, then you need to indemnify me for such. The other could be because of prior knowledge. A party may not be able to recover damages for a breach of a representation if it had prior knowledge of such a breach. So if you have the general principle that you are aware, then I can be able to provide indemnification clauses in the contract to entitle me to such recovery, notwithstanding prior knowledge of such. Now, if you look at some of the contracts you've drafted, you will note that indemnifications range from simple indemnity clauses, but there are those that extend, and I've seen this in insurance contracts, where there's a duty to indemnify and a duty to defend. Either party shall indemnify, defend, and hold harmless the other party for any liabilities, clauses, and the likes. But I note that in this count also, we don't pay attention to that drafting and what it actually means. When you talk of duty to defend in such a clause, it means that a party will defend or fund the defense of a claim at the outset. You note that in insurance companies, there's an obligation, for instance, to defend, meaning that if a party is sued, either you fund the legal fees of the other party, or you will actually step in to defend the matter. So the duty to defend in such clauses is actually broader and rises more often than the duty to provide indemnity for a loss or judgment. So you need to differentiate between the duty to indemnify and the duty to defend liability. And in most cases, our contract clauses embody both duty to indemnify, to defend, and hold harmless. We'll talk more about hold harmless later. But in minor jurisdictions, you note that an indemnifying party always has an obligation to defend. If you say, in the event of any loss or damage, you indemnify me, but there's also an obligation to defend in the case the third party claim against me arising out of such a contract. So, but when you talk of a hold harmless clause, it's a statement in a contract that states that a party will not be held liable for any injuries or damages caused to the other party. Now, again, I should have used the clause, to exemplify this properly, but you note that most of the clauses are couched in such a way that they say you shall indemnify and hold harmless. Those two mean two different things. And unfortunately, if you use them in the same clause, you risk losing indemnity because you have also contracted to hold harmless. So if I have a duty to indemnify you in the case of liability, but also the same clause says you will hold me harmless. So I've given you indemnity, but also you have an obligation to hold me harmless in case of liability, meaning you've cancelled each other. And most of these clauses are quite important in the oil and gas sector. The reason being that they want each party on a project to bear their own loss. So that's why they have clauses that say you shall indemnify and hold harmless, meaning the net effect of such clauses is that each party bears its own loss, regardless of who has caused the liability. Now, if you have a clause in commercial contracts, you want to ensure, is that what you intend the parties? If the risk of indemnification lies with the party, let's say you have a transport company, you've outsourced transportation services. The company that owns the fleet should indemnify you in case of loss. Let's say the driver has caused an accident the transport company should be able to pick the bill. But if in your contract you say you indemnify and hold harmless, meaning while they're entitled to indemnify you, you are also under an obligation to hold them harmless. Meaning, such the liability will lie, the loss will lie where it falls. No one will take benefit of indemnification because each party will hold each other harmless. So the other name for hold harmless clause is actually release of liability. You are releasing liability from the other party. You are waiving liability. So you need to be careful when drafting indemnification clauses to see whether your effect is the effect of that clause is to ensure that each party will take care of its own losses. If you do not intend to release the other party from liability, then stay clear of hold harmless clauses. Then ensure that you only have indemnification in the contract. But if your intention is to ensure that each party bears its own liability, then hold harmless clauses are better ways of risk management. So no matter what problems arise, the party protected by the clause may not be sued if you have hold harmless clauses. And most cases, the hold harmless clauses are in twofold. They could be unilateral. There's only one party who will hold harmless the other, or they could be reciprocal. If they are reciprocal, it means each party will bear its own liability. If they are unilateral, it means only one party can't be sued by the other can. So take keen interest in how these clauses are drafted. Because they actually mean different things. Indemnification is an assurance that the one party will make other party either hold for any liability. You will hold the other party liable for damages, losses. No matter what kind of indemnification clause created, it should be taken care of in drafting. Now, like exclusion clauses, indemnification clauses and hold harmless clauses are usually treated with suspicion by courts, and they're always interpreted against the party who intends to rely on them. So you want to ensure that you have clarity in drafting, but also you are able to identify whether there is no law that prohibits such clauses. I'm aware that some jurisdictions actually restrict use of such clauses, and they can be interpreted by different jurisdictions. So I won't go deep again in hold harmless clauses, but I think the takeaway is the fact that when you have hold harmless clauses, it will cover the degree of risk regardless of whether it was avoidable or unavoidable, whether it was intentional or not. Again, courts or arbitral tribunals will go back to the drafting. Did the parties intend to cover the other from all liabilities, or it's for particular liabilities? If it was indemnification, did the party intend to indemnify the other from all liabilities or some? For instance, where there's gross negligence, gross misconduct or fraud, courts have tried to stay clear of indemnification. They will always try to circumvent indemnification clauses, especially where there's fraud, there's gross negligence or gross misconduct. You want to ensure that in your contracts, you've clearly defined indemnification parameters, hold harmless parameters, and under what circumstances such can be carved out of, and what losses or liabilities are actually covered. Now, you will note that sometimes courts interpret indemnity and hold harmless clauses to mean the same thing, but others have actually identified that they actually do not mean the same thing. And I hold the same view that they serve different purposes. But the whole effect is that hold harmless clauses will release liabilities. Indemnities is to hold the other liable for the losses, but they tend to cover out third-party claims. So the other key consideration in risk management is also to ensure that in drafting clauses, you have clauses that limit liability. This is different from indemnity. This is different from hold harmless clauses. But you provide that in case of liability, my liability is capped at this level. For instance, some clauses say the the liability is limited to a particular sum, 50 million, or in case of breach or anything, you will not recover damages, or damages are capped at this level. Or in case of liability, I'm only liable to the extent of the contract's value or the liquidated damages that have been provided for in the contract. And I find that good draftsmanship, especially where in case of breach, you can't be sure of how far this court is likely to award. It could be billions depending on the judge. So from the commercial contract point of view, where you want to provide certainty, you want to provide clarity, even on the consequences of breach, you want to ensure that you embedded such clauses. And in most cases, when you are limiting liability, you want to be sure that you are clear on the types of damages, especially for complex subject matter, but also ensure that are you excluding consequential, incidental, indirect, special or punitive damages? Are you excluding future revenues, income? You note that loss of income is now something that is characteristic of the claims in the commercial court. So if you have drafted a commercial contract, you want to ensure that you limit recovery of lost future revenues, that the actual liability will be limited to these matters in the case of liability. So when you're dealing with the limitation on liability clauses in the contract, you want to ensure that your drafting is very clear. What is the party giving up? Are they giving up punitive damages, which I consider to be tortious? Are they giving up contractual damages or consequential damages? Is the clause very clear? Or is it capping? They may not limit them, but they might also cap how much can be recovered. Maybe the question you might have is that can a party contract to limit punitive damages or consequential damages? Because as we know it, assessment of damages is a discretion of court. So you probably want to ensure that you limit common law damages completely than trying to cap what is recovered. So like I said, some limitations relate to lost profits. Others limit direct damages. For instance, purchase price, the buyer might have failed to pay under the contract. Or if, for instance, under the contract, somebody had taken out loans, you may want to ensure that the damage is limited to the interest payable, not even to the business opportunity that might have. Somebody might say, because of this opportunity that I've lost, I could have made 5 billion in profit. So if you do not ensure that your contract is clear on limitations, then you risk either an arbitral tribunal or court opening up all avenues under common law to award what might be recoverable under the different tenets of damages. Yes, so these clauses that relate to indemnification, hold harmless, limitation of liability are really embedded in freedom of contract. Luckily in Uganda, we don't have yet Unfair Terms Act like in UK. So that means that, but also freedom of contract must be balanced against public policy concerns that parties who undertake a binding contractual obligation should not be free to absolve themselves from their duty to perform. And I've seen this in security services contract. When those matters come before court, in most cases, those exclusion clauses are very clear. Our liability is limited to 1 million. But if you read those cases, courts tend to say, look, you contracted to provide security. So if there's been a breach of security, you should own up. You cannot rely on exclusion clauses or limitation of liability clauses to absolve yourself from the duty to perform. But we also know that there's freedom of contract. And if you have contracted with, entered into a contract with such clauses, then you must comply with the terms. But then in drafting, you must also consider enforceability aspects. Is the clause incorporated in the contract? Is the liability in question covered by the clause? Are there any cases or legislation regulating its effect? For instance, clauses on restraint of trade. You know that even our Contracts Act has tried to limit the application. The other, of course, one way of risk management is insurance clauses. Depending on the nature of the risk, insurance is one way of managing risk under the contract. For instance, if it's an issue of personnel damage, have you taken out group insurance or workers' compensation insurance? But who will bear the responsibility of procuring the insurance required by the contract? We have to go back to the question of who is better placed to manage this risk. So that is very critical, and you must consider that when drafting. The other, of course, is you must consider insurance policy exclusions in light of the intentions of the parties. Insurance may not cover everything. There might be exclusions that are critical. Does the contract include an indemnity? If so, how are these indemnities and insurance contracts intended to fit together? Remember, insurance could be another way of indemnification. So you have agreed that you'll be indemnified in case of the loss, but also you push the other contracting party to take out insurance on the same risk. So how should that play out? And you need to be very clear in your contract how indemnity clauses and insurance will fit together. So that means you need to include severability and non-imputation clauses in the relevant insurance contracts. If somebody has gone for indemnity, maybe they can't recover under insurance. If they have recovered under insurance, they should not go again to sue for indemnification. But all that will depend on the drafting. Yes, the other, of course, limitation of liability by reference to the insurance. If in the contract I've limited my liability to 50 million, it means that the insurance I will take out is likely to cover 50 million. And that's the whole essence of ensuring that limitation of liability speaks the insurance policy also are taken out. And if somebody has taken out insurance, is it for the duration of the period of the contract? Or they will tick the box if you say take out insurance, and they've taken out insurance for the first year of the contract, but the contract is for 4 years. So what will happen to the other remaining 3 years? So it's important that if you're drafting provision of insurance cover in the contracts as a risk management tool, also bear in mind the tenure or the period of the contract. Are you covered for the entire period? I've seen, for instance, when dealing with performance bonds, while on-call demands are signature, especially in the construction space, some performance bonds provide for amortization clauses, meaning that if my performance bond is 10 million, but performance has covered 5 million, which has been paid, it means you cannot call on that bond for the full sum because the bond provides for amortization. So you must provide either in the bond or in the contract on how you will deal with amortization, so that if there's non-performance, the call is not on the full value, but it's on the reduced balance in accordance with the performance. Again, it goes back to the drafting. Then you must avoid cutting and pasting insurance clauses, because the insurance that is required, either the type or the cover, may not be specific to the nature of the transaction you're dealing with. And you must be very clear, which risks are you insuring against? If you say take out insurance, you must be very clear, which risk are you covering? Is it about personnel? Is it about property? Is it about non-performance so that you take out an insurance bond? Be very clear on the risk. And then what are the consequences of failing to obtain an adequate insurance prescribed in a contract? Is it an event of default? Can you walk away from the contract? Now that will depend on the risk appetite of the contracting party and whether taking out insurance is a critical consideration as far as risk management is concerned. I will not belabor so much on the dispute resolution clause. I know my colleague David talked about it properly, but the takeaway is the fact that we can no longer leave dispute resolution only in the hands of courts unless it is one way of managing the risk. So you can no longer say the dispute resolution clause, I'll just copy and paste from the previous argument and put it there. Parties should be able to understand and provide a forum through which their disputes can be effectively resolved, but also assess how the dispute resolution process will affect performance. Not every dispute means that the contract must be terminated. Some disputes happen during the performance, and you want to resolve them and continue performing the contract. But you can imagine if you choose court as your mode and you want to continue performing the contract. In most cases, litigation, the gloves are off. And sometimes it leads to parties not seeing eye to eye. So depending on the commercial contract you are dealing with, ensure that you provide a simple, but also an effective dispute resolution mechanism that allows escalation, that allows parties to continue performing, that allows finality in case the dispute has led to the breakdown of the relationship. And that's why multi-tiered dispute resolution clauses are now favored with simple escalation. If a matter involves technical dispute, have the technical personnel looked at it. If they have failed, have you taken the dispute to the top management, maybe CEOs, who might add technical to the business ecosystem of the contract? So, look, you might have a right here, but let's compensate and move on with the project. And the party should be allowed to negotiate in good faith. So that's why most of the multi-tiered disputes will range from negotiation to more elaborate mediation, adjudication. Others require expert determination or arbitral process. And of course, some procedures such as arbitration really prohibit recourse to court. Once you've chosen court arbitration, you only go to court in limited circumstances. Why you choose arbitration then must be final and binding, but also ensure that you choose arbitration in deserving contracts. You can, like I've highlighted, you are choosing arbitration before a panel of 3 arbitrators. Your contract value is 20 million. Each arbitrator charges around $1,000 per session. By the time your dispute is resolved, then the subject matter value is wiped out. And that means that probably the choice is not effective to the contract you drafted. You want to probably leave arbitration to high value contracts or technical contracts or contracts that involve trade secrets or confidentiality where you don't want court or public to be part of. So it's a strategic decision you must take at the point of drafting. Will the parties appreciate arbitration? Or it's a simple argument of the debt recovery, and probably I can do summary suit and recover, where a court might be the most effective dispute resolution mechanism. So it's a risk, it's a litigation risk that has to be managed at the point of drafting. So consider the contract value and the possible cost of the dispute resolution mechanism. Consider the time and the cost. Those must go hand in hand. If it's a project space, if it's a technical, do you want to be in court for the next 10 years? If it's a dispute of 20 million and say probably an IT contract, do you want court in that space? If it's a franchise agreement, do you really want to subject it to court where there won't be any confidentiality? So what dispute resolution mechanism does the specific industry seem to prefer, and why? As lawyers, we must inquire and be able to ensure that we incorporate the desires of the parties as well as the industry practice. Then the other, of course, is forum selection clauses. This is where probably you are dealing with international transactions. If you have not chosen arbitration, where will the lawsuits be? Which one is the law applicable? And I've seen quite a number of cases now in Uganda where a choice of law clauses have been enforced, especially where parties have chosen a foreign law jurisdiction. If parties say that the law applicable is English law, it will be enforced. If you say that Mauritius law will be applicable to the transaction, so be it. So our commercial court, for instance, has been keen to enforce a choice of the parties to the forum as well as the law applicable. But you want to ensure that when drafting, you choose a home country that is acceptable to the parties, or is neutral if parties are from different jurisdictions, or a jurisdiction that is familiar to the parties. Maybe not to the lawyer per se, but to the parties. And you don't want to be in the other party's backyard to fight about the same legal issue. You know that some of you have drafted arguments involving British companies, they always prefer English law because they want to fight you in their own home turf. And do you think you will have same bargaining power in courts or in the interpretation? And if there's an arbitration clause, where is the seat of arbitration? And the seat of arbitration has consequences on the arbitral process. It determines the law of the award. It determines the courts that will provide support to the arbitral proceedings. It will determine the law that will be the basis to set aside the arbitration award if it is necessary. So when drafting the arbitration clause within the commercial agreement, please ensure that you pay keen attention to the seat and the arbitration clause in whole, because it's part of the risk management tool in commercial contracts. So again, in terms of the choice of law clauses, parties now can negotiate which law will govern their contract. They will need to specify the choice of law clauses and the jurisdiction, which court will administer the justice in the event of a dispute. Although the right is that the choice of law clause may not completely shelter a party from having the laws of other countries imposed upon them. For instance, claims by the third parties. If you have CNOC, let's say, and TARO under the joint operating agreement, choose English law, and probably in the execution of that contract, they are subject to third-party claims in Uganda, let's say employment matters. They can't take them back to English or French law. So the third-party claims may not insulate parties from their choice of law. So the other key consideration and also a risk management tool, of course, is the force majeure clause. Like I said, it was less popular previously and people would just copy and paste. But right now with COVID lockdown, it has actually reignited the debate and the negotiations on force majeure clauses, because many parties have realized that actually you can be affected. So it's very important when, in terms of drafting, you anticipate what are some of the events that would lead to force majeure. And the typical or the yardstick is that these are matters that should be beyond the reasonable control of the parties. The old interpretation was all matters that are considered act of God. And that's why aspects like frauds, natural calamities were considered force majeure. But the recent jurisprudence and interpretation of such clauses actually relate to circumstances beyond a party's reasonable control. And the catch is reasonable control. So there could be natural calamities, but also other matters that may not necessarily be natural calamities. There could be legislation that might come and impose something that affects a business undertaking. That can be a force majeure. But the critical aspect is that you must ensure that your clause is detailed enough to avoid such. But also consider what will happen if a force majeure event happens. Do parties just walk away from the contract? What will be the obligations of the parties at that point after the force majeure event? Because the natural consequence under common law is the fact that parties are no longer liable and they can walk away from the contract. But it's not always the case that parties want to walk away, even if a force majeure event has happened, especially with project finance documents, project structuring agreements. So the drafting must be key, and also ensure that there's an interplay between indemnification clauses with force majeure events as well. Is it that if there's a force majeure event, then indemnification will be suspended, or a party will be indemnified regardless whether the force majeure event has happened? And the last part is really early termination risk. Now, termination, again, is something that we always copy and paste. And when you look at some of the clauses, termination is always by convenience. Either party might terminate by giving 1 month notice, 3 months notice. And sometimes we don't interrogate the critical commercial terms of the agreement to ensure that we craft the termination clause to avoid, for instance, early terminations that might jeopardize or prejudice the other party. So you want to ensure that what will be the effect of early termination, for instance. have you considered tangible and intangible property disposition during termination? What will happen if there is convenience-based termination? Convenience-based termination is usually that termination by giving notice. You don't need to justify why. You only need to give notice. So if you are to adopt termination for convenience, have you considered the underlying commercial terms? I can give an example. It's a commercial contract where one party has to invest for 2 years before they can recover any profit. And you want to provide for termination for convenience, and you don't provide for compensation in the event of termination. So such termination by giving notice is properly within the contract and is not a breach. What that means is that parties have appreciated the risks, and that if they terminate for convenience, somebody who has invested in money, they will lose it unless they have provided other mechanisms on how to recoup that money. So you need to consider exit provisions from the start of negotiations. Unfortunately, most of the clients want to consider them when things go wrong, which is sometimes very late. So the termination clause should be considered as important as any other provision in the agreement, which have immediate effect. So payment obligations for under exit provisions are likely to incentivize. People need to think carefully before they terminate an agreement, especially with the commercial nature. So termination clauses can actually have a potential win-win areas. For instance, you will provide assurance for the customer that exit will not cause any undue business interruption. Imagine you are provided core business system or core banking system to the bank, and you terminate after 1 month. You can imagine what that will mean to the bank. Or you're provided a learning platform to a university and you terminate it immediately. You will frustrate the entire operations of the university. So exit provisions provide assurance that you will deal with business interruptions. It also provides clarity to the supplier about its obligations and revenues on exit. Then you provide a managed clear path exit for both parties, so that you avoid unnecessary negotiations on exit when relationships may have deteriorated. Sometimes by the time parties are terminating, they are burnt bridges and gloves are off. So if you do not have other provisions on how to deal with exits, you will have challenges negotiating exit at that point. So the starting point really is to ensure contractual termination rights at that point. Because generally, contractual termination right will operate in addition to common law rights to terminate unless the latter are expressly or impliedly excluded. I've had the benefit of arguing a contract where the parties provided that termination will be by notice, and the notice will be 6 months. So that means that a party could not terminate without giving 6 months notice. Now, there was a fundamental breach of that contract, and the termination clause had not expressly excluded common law rights on termination. So I argued that fundamental breach of a contract allows the other party to repudiate, and unless the contract has expressly excluded common law right, then my client could actually repudiate a contract if there was a fundamental breach. I know this was in relation to an arbitration, so it wasn't subject of a court deliberation, but the arbitral tribunal agreed with me that indeed the contract did not exclude common law rights. So if you have provided an elaborate termination clause, you want to ensure that common law rights are expressly excluded. If, for instance, you provided events of default or termination events, so that means other events outside that cannot amount to a cause within the meaning of that contract. Yes, so you want to ensure that if a commercial contract is of high value, it's very important to your clients, avoid termination without cause for convenience. You want to ensure that termination is with cause, and you've clearly highlighted events of default or breaches that should entitle the other party to terminate. And if you think common law remedies are still relevant, then you can actually provide a clause that the parties' rights under common law are preserved as well. Or if you want to exclude, then express a state that they are expressly excluded. So you need to consider what termination rights each party shall have and clearly define the relevant circumstance enabling each right. For instance, if termination for convenience may evoke an early termination charge, you can preserve the right to terminate for convenience and say, if you want to terminate for convenience, then you must pay me the full value of the contract. So if you want to leave, it's okay, but pay me. The charge will be the full value of the contract, or compensate me for the full value. If it's termination for cause, which is usually a breach, then what is the material breach? Sometimes such clauses include a time limit for remedy or repeated breaches, or if it's a fundamental breach, one event might be enough. Others could be for insolvency or expiry of the contract. So even if you do not provide for a termination clause in the contract, there's a common law right to terminate for repeated breach. That is preserved. But also we know that under the Contracts Act, there are those rights to repudiate that are provided for under the law where parties have not expressly provided for such remedies. So when we talk of termination for conveniency, it operates unilaterally in nature. So one party chooses to terminate and that's it. And here it grants extreme and broad rights to terminate the other party's performance without being able to be liable to breach of contract damages. And in most cases, it precludes the recovery of anticipated profit, that is lost income. So if you are to accept termination for convenience clause, then you need to advise the client to include, first of all, provision for reimbursement of actual costs incurred. So if somebody can terminate by giving notice and I've spent money worth 2 years, then reimburse my money and probably interest. You need to provide reimbursement of the cost of settling and paying termination settlement to staff who are dedicated to the contract. Sometimes people hire staff to perform a particular contract and they may not absorb them in their normal operations. So you can imagine if you allow termination for convenience, you have an entire setup purposely to perform that contract. So what will happen if there's termination for convenience? Then you can attempt to lengthen the term notice a longer period. If termination is for convenience, give me 6 months notice so that I can lay off the staff, I can retire my loans, I can sell off the properties that I might have acquired purposely to perform this contract. So we've talked about termination with cause, which only allows the party to terminate generally immediately upon the occurrence of certain defined events, which are usually called events of default. But also it includes material or repeated breaches of the commercial contract. And usually non-payment is another common ground of termination. So you want to ensure that if you are to include termination with cause, your events of default clause is well drafted and provides clarity to both parties under what circumstance they can terminate immediately, under what circumstance they'll be allowed to remedy the breach, and under what circumstance they might be entitled to payments or liquidated damages. Sometimes it requires notification obligations to say if I've caused the breach or if it's an event of default, for it to be an event of default, you must notify me within a particular period of time. And that provides certainty. So it is also possible to include bespoke events which provide grounds for termination and which are dependent on the particular circumstances of the commercial arrangement. So the events of default are not generic to every business or to every contract. Some might be specific to the parties before you. Others are material breach. I will not go in detail. It's an extension of events of default, but it's also important to consider what is defined as material breach and what will happen in case there's a material breach. So the other key consideration, of course, I wanted us to go back to is IP rights on exit. You can imagine you have a software contract or you have a commercial contract that has intellectual property rights. So a decent drafted termination clause should provide for IP rights on exit that might have been created. How do you deal with them? Do you destroy software? Do you return it back? Within what period? Then you should also provide argument on ownership of these deliverables at the point of exit. And consider what impact termination may have on these IP rights. Do the intellectual property rights terminate or continue, and for how long upon exit? Sometimes people provide for a longer period of IP rights beyond the termination date. Will IP rights need to be assigned? What will happen? You recall the big battle between Plascon and Sadoli. I know we may not have had the full story in the courts, but it was an issue again on the IP rights and the license. What should happen in the event that we terminate? So the contract and specifically the termination clause should provide the transition or the exit strategy on how to deal with such intellectual property rights. Then the default position is usually the author of such retains ownership, but ensure that the IP rights indemnities survive termination. This is particularly critical for the party being indemnified. So what are some of the best practices dealing with termination? It's important that your clause provide an initial exit plan, pricing mechanism, compensation at the contract signature. It's the best time to provide for an exit plan and transition, and deal with the continuation of the services before and after termination date. It's not always the case that every contract you can easily terminate and move on. Some contracts require integration of businesses to the extent that to terminate, you must gradually exit in a phased manner. If, for instance, you have a contract for provision of laboratory services to a hospital, and you know that the hospital is fully dependent on the laboratory services to perform their obligation, and you decided to terminate it, you can imagine the net effect of such termination on the healthcare, on the hospital, on the patients. So if you do not provide for the performance of the services and the exit services in the event of an exit, it could be a big challenge and might cause reputational issues and damage to the parties. And in most cases, you must consider that the exit obligations are different depending on the reasons for exit. Avoid scenario where no pricing is included, but the exit provisions are sufficient to trigger obligations. So your pricing at the point of exit should also be managed to know that this is how we'll calculate the price. If it's, for instance, a lease agreement, machine lease agreement, what would be the price at the point of termination? Will it be negotiated? Have you fixed it? Is there any variable that will help in determining the price at that time? So a robust and comprehensive exit plan must clearly map out termination process in order to provide business continuity, to prevent disputes, but also to provide clarity on parties' obligations. And more importantly, you need to minimize the disruption and delay during the transition. Because sometimes another party would want to engage another party or to see how they can take up the obligations. But also, it also ensures that the outgoing supplier cooperates with the new incumbent during the exit. So termination clauses should address planning for exit, when exit occurs, and post-exit. So some of those clauses that are one-liner, either party might terminate by giving 1 month notice, may not be the right approach, especially in commercial contracts. The other risk that is always prevailing in commercial contracts is reputation. So you need to control, from the contractual point of view, control the flow of information and data, incorporate data protection within the contract. How are documents controlled? Do you have cyber security policies and procedures embedded within the contracts of staff and consultants who are performing? Have you provided for confidentiality in dispute resolution mechanism? In service level agreements with consultants and advisors? I know sometimes lawyers will tend to want to talk about the deal or the contract we are handling at the counters and the coffees with other people. That can expose an organization. So you want to ensure that different service providers are also obliged to keep confidentiality for such matters. And that's why non-disclosure agreements are very important for different people serving in the ecosystem of a particular transaction. And of course, to ensure that the contract may not be the only answer to reputation. You've seen situations where people even provide alerts, media briefings when they know that there's a potential termination, so that they're the first to deal with their clients and stakeholders so that they can manage the reputation better. Those are some of the tools outside the contract. And the second last, of course, is on execution clauses. I thought I should highlight this because we know that there are some contracts that are specific on how they should be executed. Ensure that you've complied with the methods of execution. How does a company execute a contract? How do NGOs execute contracts? Have you complied with the relevant legislation to determine execution? For instance, under the Registration of Titles Act. For review, have the parties correctly executed the contract? Because that goes to enforcement, to the validity of the transaction. If you have different schedules and appendices to the contract, have they been expressly incorporated as substantive part of the contract? Or the purpose is to separate much of the specific deal from the boilerplate clauses, but also to ensure that the hierarchy of those documents are well referenced in the agreement, because there could be challenges that there is inconsistency, and where the project specific deals are in the schedules, then you conflict them with the main contract and you can't know exactly which takes precedence over the other. What could be the takeaways? If you are to use standard provisions, ensure that you review them, because they can materially differ from your expectations. And relying on another party's standard documentation can have costly consequences. So while precedents are important, customize them. So good standard documents can help you to negotiate from a position of strength. It can save you money and provide an avenue for you to recover damages for breach. And I can assure you, bad documentation can result in expanded liability and costly litigation. The takeaway is also, as lawyers, before we draft that agreement, before you review that agreement for risk management tools, ensure that you comprehensively understand the transaction in the business sector. If you're dealing with lawyers, have they gotten in touch with the user departments? Appreciate their understanding of the commercial deal so that you appreciate the risk that you are taking on. Understand the client's objectives and limitations and the risk appetite. That way it helps you to structure the risk management tools better. Educate yourself concerning the opposite party and its professional advisors. We know that some lawyers, if you reach out, you will have less time in negotiating certain provisions. It will help your client better to appreciate risk allocation and transfer tools and without creating impasse. Define legal and commercial issues in the transaction. And that way it helps you to define the risks and how to manage it. I must re-emphasize that we must re-educate ourselves on all applicable laws and regulations. It will be disheartening that the last risk you've ignored is actually the legal or regulatory risk, or there's a step that you did not take to ensure that the transaction is enforceable. Assess your qualifications and limitations for the transaction and get help. Sometimes we are not always at the top of our game on each and every transaction. Within the sector, we know so-and-so is very good on M&As, we know so-and-so is good on PPAs. Consult so that you are aware of some of the nuances that you are not probably aware of. So within the context of the commercial agreements, ensure that you comply with the requirements of the law, embody the provisions of the negotiated transactions as opposed to standard clauses, protect your client's interests, and ensure that you outline the transaction in a logical manner, bearing in mind some of those negotiated terms we've talked about, and accurately describe the agreement for any third party to comprehend the arrangement. I think there are quite a number, but I just wanted to end with this in terms of risk management is is part of risk contract management. And you want to ensure that the contracts are planned and worked at the point of contract creation. And you have means of tracking and monitoring the cost, time, quality, and deliverables. And these are part of the risks that we need to be care of. What are the roles and responsibilities of the parties? Have you been able to manage relationships within the contract space? Have the payments been well managed? Have you anticipated problems and managed them from the risk management point of view? And the tool should be able to ensure clarity, quickly, effectiveness, and fair management of disputes in a transparent manner. I thank you very much. I know it's been long, but I thank you for giving me your attention.
Wow, members will agree with me that that was an enlightening discussion from Patson. Patson, thank you very much. And I had a couple of light bulb moments as you were presenting. And as a transactions lawyer, I know you've increased my arsenal of arms in terms of negotiating and structuring deals for clients. So thank you very much. I see we have a couple of questions from the members for Patson. We have a question from Kaliba Edison. Is it possible to have the presentations of the panelists shared with us? Definitely, we'll share these after. We have another from Hilda Joy. She says, thank you for the great presentation, Mr. Rinitre. Her question is in relation to clarity of ownership of IP rights as presented. She's wondering if it is in order that when drafting a contract that is in relation to IP rights, the authors and owners of the intellectual property at every stage have to clearly be laid out. She's also wondering, doesn't this make the contract seem convoluted if a number of people own the different IPs at the different stages?
I could start with that.
Yes.
I thank you, Hilda, for that question. And it's a valid one in terms of commercial transactions. It's important that IP rights are actually clarified. And this will relate to different commercial transactions. I can give an example. If you're dealing with provision of a core banking system to a bank, chances are that you have different IP rights. So to avoid the contract being convoluted, you can prepare it in such a way that you have appendices to the contract should have schedules. So the details of the ownership or license is actually attached as a schedule to the contract, so that the details are not lost in the specifics of that contract. So one, you ensure that there's licensing. Instead of defining different ownerships, you can have one owner or different owners who have licensed or given user rights to the other party. So the cleaner way to do it is really to ensure that you have details that are attached as appendix to the agreement, and parties obliged to comply with the specifics that have been provided. So that the body of the contract only addresses to the core of the parties' commercial deal.
Thank you. So we have a couple of reactions. Everyone is very grateful for your elaborate and insightful presentation. So thank you very much. As we are pressed for time, we're going to take a short break and come back with our next presenter.
Thank you. One break?
Yes.
It's hot.
I know. Can I share my email?
Yeah, sure. Yeah.
That was my We have our third and final panelist, Mr. Ellison Karuhanga. Ellison will be taking us through structuring smart commercial contracts. Mr. Karuhanga is a partner at Kampala Associated Advocates, our host for this webinar. He is in the litigation and energy department. He's a trained oil and gas lawyer, having obtained a master's degree in oil and gas from the University of Aberdeen. He's also a member of the Uganda Chamber of Mines and Petroleum. Mr. Karuhanga also has experience in the banking sector, having worked with financial institutions in his previous years, and represents clients in the banking sector. Mr. Karuhanga's peers say he's an adept litigator, is effective, is efficient, and expeditious in court. So, Mr. Karuhanga, we look forward to your presentation. The floor is yours.
Thank you very much. And greetings to everybody who is here. I was given a simple task to present on the structuring of commercial contracts, and I am sure that there is nothing useful I can actually add to the presentations that have gone before me, but I will nonetheless try. I think we can start to the first slide. Under Section 10 of the Contracts Act, you all know what a contract is. If we could move the slides. It has all those elements. It is an agreement made with the free consent of the parties with the capacity to contract for a lawful consideration and a lawful object with the intention to be legally bound. Commercial contracts are the backbone of modern commerce. They're about the legal framework for businesses to operate, ensuring that parties can work together effectively and efficiently. How I would like to define commercial contracts are they are money in motion. Nobody pays you without a contract and without following the terms of the contract. Are you supposed to provide him with an invoice? He's supposed to pay you after 20 days. The beginning of the money to flow to you is the contract. So commercial contracts, I would say, is simply money in motion. If you want money, you need a contract, generally. They come in many shapes and sizes: purchase agreements, lease agreements, financing agreements, some insurance agreements, petroleum agreements, loans, share purchase agreements. And what is important is that almost every type of commercial agreement is actually governed by a different branch of law. If you're looking at rental agreements, you're going to have landlord and tenant laws. If you're looking at insurance contracts, you'll have insurance laws. If you're looking at hire purchase agreements, there are laws on hire purchase. If you're looking at leasing of land, there are laws on that. If you are looking at petroleum, there are laws on that. If you are looking at almost every specialized area of commercial practice comes with a certain body of legislation or a body of rules that govern it. And the real way you can be good at these commercial contracts is by understanding the subject that will be the subject of your agreement. I'll try and rush through this presentation very quickly because I know that we are about to be interfering with blood sugars. But another key aspect of commercial contracts is risk management, which I'm told a great deal has been done in previous presentations. Clients have to be protected from risks, and risks is also about law, but different agreements carry different risks, and each party to a commercial contract seeks to minimize risk and maximize its reward, which is what creates the inherent tension between contracting parties. Someone says, what if this happens? What if that happens? What if that happens? I need to be protected. And the other person says, what if this happens? What if that happens? I need to be protected. So the balance between risk allocation. Now, of course, different industries allocate risk differently. How do you allocate risk in a way that protects the inherent underlying commercial agreement? Now, I know many of you will remember the issue that contract law used to have with our friend the exclusion clause. This was the clause which says the person is all liability is excluded. You have entered into an agreement, and if all goes bad, that is your problem. And it was based on the principle of freedom of contract. And in his last judgment, which was actually a dissenting judgment, Lord Denning, the master of the rules, famously said that I think that's the case of George Mitchell, Chester Hall Limited versus Finney Lockseeds. He said that how judges came around the problem of the exclusion clause was they did what they could to put a curb on it. They hid behind the idol, freedom of contract. They still knelt down and worshipped it, but they concealed under their cloaks a secret weapon. They used it to stab the idol in the back. The weapon was called the true construction of the contract. They used it with great skill and ingenuity. They used it so as to depart from the natural meaning of the words of the exemption clause and to put on them a strained and unnatural construction. Now, basically what Denning was saying there, he was boasting that in his 20 years at the appeal court between 62 and 82, he and his colleagues at the bench had introduced very many new techniques in interpreting the construction of contracts, what he calls the true construction of the contract, rules like the contra proferentum rule and the various rules that govern the construction of contracts. And what he was basically admitting to is that they were just simply stabbing the concept of freedom of contract. That means that you can agree something, but once it goes before a judge, the judge himself can look for a way to kill your agreement. And Denning was very happy that they had done it with what he called great skill and ingenuity. So judges still have the power, wherever they are in common law systems, to distort the English language. They have the power to give a judicial distortion of English. They have the power to tell you what shall is, what will is, what may is, and even what is, until you are just in a state of quagmire. That is why it is very important when putting down these agreements to put down something that will survive the test of judicial scrutiny. That is why it's very important to understand that the way you allocate risk will depend on the way on the underlying fundamentals of the agreement. Now, if you look at I'll give a good example of the petroleum industry. Risk generally is allocated. What happens with contracts is that if you breach the contract, the party who breaches, pays. If it is in tort, how liability flows in tort, it's either a breach of a statutory duty or it's negligence. In the petroleum industry, when it comes to insurable risk, accidents, if you are there and you are, because there are about so many companies on a platform, because oil companies simply look for oil, but everyone does everything else, and including drilling. They don't drill, they hire, they outsource for the reasons we can get into later. But what they have designed their platforms, and when you look at their contracts, their risk allocation in those contracts is that every person looks after his own people. So in short, when you are a cook and you go there, your agreement will tell you that in the event of an accident on this platform caused by another party, you guarantee and hold harmless every other person to compensate you for a problem that they have done. Why? Because the nature and expensive nature of the platform is such that the bigger party carries the bigger risk. If the cook goes and burns everything down, you don't expect the cook, the company that provided food, to be able to pay the billions of dollars that constitute a petroleum platform. Yet at the same time, if you ask him to insure for it, the insurance that he will get will make the cooking of food completely uneconomic. So to stop this, they allocate risk in such a way that the bigger party bears the bigger risk, but each party bears the risk that that party can absorb with very limited exceptions. Now, in the United Kingdom, in around was it in the 70s or 80s, there was a fire on a platform at an oil platform called the Piper Alpha. It was a huge accident. About 89 people burnt to death. And people sued, of course, for compensation from different companies. They would sue their companies, and the companies would seek to get indemnities. And the English court, when they looked at the structure of petroleum contracts, held that it is inherently improbable that one party should intend to absolve the other party from consequences of the latter's own negligence. So again, they went into, it took a long time for oil industry players to be able to convince English and Scottish courts, especially, that were handling the Piper Alpha, of how their industry works. Now, risk allocation, therefore, is a fundamentally important part. How you structure, who is responsible for what, is a big part of the contractual matrix. The other is the dispute resolution and governing law clauses. Now, many times countries put in, I'll start really from the last point, the issue of the bits and meets. Countries have bilateral investment treaties and multilateral investment treaties. In order to attract investment here, you go and you sign an agreement with Netherlands, and also I forgot to put double taxation agreements. So you go and you sign an agreement with the Netherlands, you go and you sign an agreement with Mauritius, you go and you sign an agreement with the UK, you sign an agreement with India, you say that, and many of these bits, those are bilateral investment treaties and multilateral investment treaties. ACP, African, Caribbean, and Pacific states, many of these contain arbitration clauses that investors from those countries can rely on to challenge decisions of host governments, irrespective of what they have agreed to with you or not. So you have a situation where no, go back to the previous slide. You have a situation where you have the bits and the meats. So I'll just give you a few examples of how they work. The Yukos case with Russia. Yukos was a company owned by a man called Mikhail Khodorkovsky. He was the richest man in Russia, but he registered Yukos in the Netherlands, the parent company. Now, Mr. Khodorkovsky, of course, had a fundamental disagreement with the government of Russia, and after his disagreement, or maybe during or before, depending on who you ask, they determined that he had been evading taxes. So they decided to do many bad things to him, which I don't need to go into. But one of the bad things was they took his company. So instead of filing a lawsuit in Russia, the Yukos shareholders filed an arbitration, claiming that Russia was a party to the Energy Charter Treaty, which protected companies that are registered in Europe and gave them the right to international arbitration. Russia, of course, argued that Khodorkovsky and even his minority shareholders had such a limited interest in the company to warrant a right at international arbitration, but also that Khodorkovsky was Russian, fundamentally. But the arbitral tribunals refused. And I think it's the largest single arbitral award, $50 billion probably, maybe more, I need to check. And that award is currently the subject of many challenges in the Dutch courts. Some of them are still ongoing, but in light of what's happening now, I don't know if the Russians can have a fair hearing. Venezuela and Exxon, a similar story. ExxonMobil registered in Netherlands and had a bilateral investment treaty with Venezuela. When Venezuela increased tax on ExxonMobil to 99%, they called it an expropriation of their assets. And then they went into a dispute with Venezuela, and Venezuela said, but these Americans, we don't have no treaty with America. And I think it was Exxon and ConocoPhillips that said, no, you have a bilateral investment treaty with the Holland, and our holding company that was a share in this company is Dutch, and therefore we have. Then of course you have Uganda Heritage. that one, it was similar. But there were decisions also of the High Court here about the ability to arbitrate on tax matters, because tax being a creature of statute, but also there were questions of jurisdiction. There were questions of whether that agreement fell within a double tax agreement between Uganda and Mauritius. Heritage, immediately when they were going to be paid, they became Mauritians and turned up here and said that we are Mauritian citizens and there's a double tax agreement, and capital gains does not apply. I think that was one of the arguments. Of course, the issue then, the arbitration tribunal actually went into that issue, and I think there was I don't have all the facts with me, I think, but I think there was an issue of whether it was a movable or immovable asset. Heritage arguing that petroleum moves, it moves every day. You actually use it to move. It is a moving thing. It moves through pipelines. It moves through refineries. It moves in cars. It moves. And the Uganda government arguing that actually the license Heritage had is in Bulisa, that Bulisa actually doesn't go anywhere unless you are saying the earth shall go around the sun, which does not constitute a movable. Anyway, we can move to the next slide. The point I wanted to make is that even after you draft your agreement, even on an issue like dispute resolution, we have, for example, the Investment Code Act, which gives certain rights to people to enshrine those bits and meats in law. You have, even after you draft your agreement, you have to look at the entire body of the law before you can make very serious conclusions. I think we can move to the next slide. Now, in these contracts, of course, there are necessary clauses, what they call boiler point clauses. Definitions. Many times you have to define what words mean, because like I've told you, their lordships can decide to give English its own meaning. So sometimes you may have to say was means, is means, but also more importantly, other things, where the male shall include the female and the female shall include the male, where the hour shall include the minute and the second. But you have, but generally, a definition clause on the technical terms. If you're looking at aviation, yeah, what are the technical terms in an aviation contract? If you're looking at an agreement for whatever the complicated agreement is, what are the technical terms? The scope of work, the construction contracts, especially between the engineer, the employer and the contractor. You have these tripartite agreements, you have these red books, and you have all these amendments within them. What are the specific tasks? What are the services? What are the deliverables? Time frame. Is time of the essence? What is when does the contract commence? What is the start date? What is the end date? What is the period? What is the responsibilities and obligations clause? What are the responsibilities of each party? What obligations do they need to fulfill? Payment and pricing consideration, basically. And the billing procedures. So you have the situation where you have to provide invoices in time and things like that. The day you should provide your invoice, what your invoice should accompany it with. Someone says you must come with a receipt of this and this, blah, blah, blah. Termination clauses, of course, how can the contract be terminated, extended, blah, blah, blah. Confidentiality, many times, how do you deal with confidential information? Limitation of liability, aviation contracts especially have those, and many other contracts actually. And even limiting your liability to the extent of consequential loss, issues of consequential loss. Of I lost power, you have an agreement to supply me with electricity. Electricity was off on Monday, and because it was off on Monday, it was the only day I had to be able to find gold. And now I cannot find the same gold on Tuesday, and therefore not only must you pay me for my loss of power, you must pay me for my loss of gold. So many people limit liability and look at issues of consequential loss and say, how do you handle consequential loss? Dispute resolution, of course, dispute resolution, I think we have dealt with it partly. Where do you solve your dispute? How do you solve your dispute? Yeah, I think we can move to the next slide. This is the last slide. So the main points are: know the area of the law, understand the basic commercial interests of the party, see how risk is factored, as is allocated, and factor in the crucial clauses. With those very few words, I am sure that the bulk of this presentation had been handled previously by my colleagues. And I'm sure that there are no questions, all of them having been successfully answered by Patson and David.
Absolutely. Thank you very much, Edison. Members, you can clearly see it was concise and to the point. We have all gotten more than our money's worth, so we can go the rest of the day satisfied. It has been my absolute pleasure moderating. Is that? Oh, sorry. Perhaps there are some people with reactions, hands up, questions. You can shoot now while we have Edison here. Okay. Bear with us. Philip Munabi, you've been unmuted. You can pose your question.
Can you hear me?
Thank you, moderator. Mine is not a question, but I felt I needed to give a vote of thanks to the presenters.
Okay, go ahead.
It's been a very wonderful presentation and teaching session. It's more or less a lecture. There are so many things we've learned today that we may not have learned in school or elsewhere. I thank the three presenters, Patson, Ellison, and David. I commit to attending the CLI arbitration workshop that I've been saying, which is on 11th and 12th, just for the introduction bit that I have obtained from this session. Thank you.
All right, thank you, Philip. Anyone with a question before Mr. Karuhanga exits? Any other? I see there is a question about sharing slides. Admin, ULS will share the slides after the presentation. There's a question from Winnie Amos. Are there particular textbooks or course certifications that the presenters have taken or read in order to increase their expertise in this particular area of the law? So, Edison.
Yes, there are of course very many write-ups and courses that people have taken in order to understand the principles governing commercial agreements. I think that people, for example, become I think there are very many agreements. There are very many. That's why I said it depends on the area of the law. It is too wide an area to have to speak of a specific agreement, but there are there's a lot, for example, in terms of what happens with FIDIC contracts. I don't know if FIDIC contracts were presented on earlier, but there's a lot of literature on FIDIC contracts and on how FIDIC contracts are arrived at. There is certainly a whole body of law on energy contracts. There's a whole body of law on the different types really of agreements. There are different types of agreements, especially standardized agreements, international agreements. I think there's a whole body of law and a whole spectrum of literature from different areas. I know that the people who conduct the best contract training, I think, are people who do FIDIC agreements.
There's another question from Brenda Friday. Would you please recommend a contract management software that an in-house team can use to manage contracts from drafting, execution to storage? Thank you for the elaborate presentation.
There is actually a lot in terms of AI that's happening right now. Of course, I don't know if you're part of PLC, which is this is called a private law company, or practical law company that provides a lot of templates, huge amounts of templates on literally any area of the law that you can imagine. But there's also a lot of it's called it's called AI, artificial intelligence, that really is developing in incredible ways. And I think we may need to have as ULS a conversation on AI in the legal space, particularly with regard to contract drafting. I know of a number of apps. I've heard of a number of apps that don't come off head immediately, where people simply put in certain details and get back certain contracts. The credibility of these contracts, the efficacy of these contracts, the seriousness of these contracts may be challenged, but there's certainly a huge danger that in 10, 20 years, or maybe even less, people will be using AI more than they'll be using us. And that's something we need to really look at. So when you talk of, and especially when you see it's a question coming from in-house counsel, that is a serious attempt to remove us from from this work.
All right. One final call for questions before we call it a day.
And I thank Philip Munawi, of course, for his very gracious vote of thanks.
So once again, thank you all for joining us, for paying utmost attention. And thank you to the panelists who have enriched us today. And it's been an absolute pleasure being a moderator today. My name is Agatha, in case some of you missed the introductions. So have a wonderful day, and all right.